each other, it can be very difficult in Zoom meetings. So if you can manage that, John, people can either raise their hand, or there's a button on the Zoom that you can hit to raise your hand that you want to talk. But frankly, I've been doing these a lot over the last many months. Raising your hands and just getting a nod is a good way to go.
Okay, hey, thanks for the pointers.
Yep.
You didn't mention cell phones. I assume everybody's got their cell phones shut off, or is that necessary?
Not sure it's necessary.
Okay, all right. The
thing I would say is the corollary to what Jeremy said is, and I'm going to do it right now, everyone should mute themselves if they're not speaking. So go to mute of your audio.
As co-host, I may mute you just so you know.
Okay, we're ready. The Camden Zoning Board of Appeals for Thursday, July 9th, 2020 will now come to order. I take it that we're not going to hear from Audra in any respect regarding communications then, so we'll move right along. My name is John Cool. I am the vice chair for the Camden Zoning Board of Appeals. I live in Camden. I have lived here with my wife for 20 years. I live on Mill Street, and I've been with the Zoning Board of Appeals for 4 years. There's 2 points that the board would like to make before we begin with the agenda. The Camden Zoning Board of Appeals, first we ask everyone to be mindful that because we are dealing with a long-term issue with controverted positions, we all will need tonight to be our individual better selves. You can count on the board to do all that we can do regarding the same. Secondly, and really pertains to the first point, time management. We will all need to be careful. Many need to be heard. Meetings can easily descend into overload. Let's all do our part to be clear and especially concise. Now, regarding the process of the agenda, I'm going to deal now with our board, and we have present John French. We have present Ron Van Ostall. We have present Steve Beveridge, and we have present Chriso Renault. We will vote later in the agenda to bring the 2, Steve and Chriso, from alternate to full member status. But right now, we need to have a round the horn declaration if there's any conflict of bias. John French? Yeah, hear from you, John?
Just so you're aware, John's having audio problems. He's not getting clear broadcast.
Okay, let's move on. Ron Van Ostall.
No
Do you have any
problem. No conflict.
Thank you. Steve Beveridge.
No conflict.
Thank you. Chris O'Rion.
No conflict. It's a row, just FYI.
I'm sorry. Do that one more time. I apologize.
My last name is Rowe,
Rowe. Oh.
but I have no conflict.
Or did I butcher that one? Thank you very much. And I do not have a conflict. From the source of the notice of violation, Articles Section 1 and 5 and 7, Sections 3, parentheses 7 and parentheses 9, Administrative Appeal, the applicant Pleasant Ridge Homeowners Association for lots 68 to 79 with the agent Jesse Rudder comes before us. The location in concern is the lot reserved for green area as shown on the amended subdivision plan approved December 6, 1995. I've got somebody in the car here.
We're the Uris. We are the side of the green space that is not the burrito.
I'm gonna need some help here from someone.
John, can I?
They need to put you in the waiting room.
Yeah.
So you're gonna see a screen that says, please wait. And we're gonna put you in there until the ZBA votes on
Having you in.
having you in.
I'm gonna back up a second here. John French, is your audio working?
I've just asked John to call in with his cell phone and use the cell phone audio.
I don't know how to raise my hand because I'm not on audio,
Jeannie,
but
Jeannie, you can just show us with your hand. We can see you.
you can see me?
Yes.
No, I'm not on video.
No, I can't see you, Jeannie.
I
No,
can.
I'm not. You can?
I
can.
cannot. Jeannie,
Anyway, if John wants to come down to the office, we can put him live here. It's up.
if everybody agrees, we can pick up the conflict of bias later.
I don't have a problem with it, John.
Hey, Audra, I'm sorry about this, but we've got some other folks. There's a 603 number and then a Heather Cohen. I think they ought to be into the interested party waiting room, if possible. All right, does it look like we've got them into the waiting room now?
Yep, they're all in there.
Thank you. John, proceed, please.
Okay, there we go. All right, moving right along. We have some preliminary matters. We have 5 individual parts to the preliminary matters. And I need to read something to you again. I hope I'm coming through nice and clear here, but I don't want to do this twice. The following procedures will be followed for the public hearing process. 1, the CEO will introduce the application and explain why it is before the Zoning Board of Appeals. The board will hear from the applicant or the applicant's representative who will offer testimony and evidence in support of the application. 3, the board will then seek comments from the members of the public who want to speak, comments or ask questions. Questions and comments will not be taken from the floor so that all comments can be heard by those in attendance, as well as those watching the broadcast or live stream of the meeting. Speakers must come forward to the microphone and identify themselves for the record by name and address. 4, the comments and all questions of the applicant must be directed through the chair. The chair may exclude irrelevant or unduly repetitious comments. Number 5, the first public comment period will be closed and members of the board will be given the opportunity to ask questions of the applicant and or the public. A second public comment will be open for the purpose of hearing new and relevant information only. 6, the second public comment period will be closed, and if members have no further questions or comments, the public hearing will be closed. 7, the board will begin deliberation. There will be no further comment from the applicant or the public. A board member may ask for clarification, but no new evidence may be entered into the record or way of testimony unless it was erroneously omitted. It is not appropriate for the public to interject during the zoning board deliberations phase of the review. Lastly, number 8, the board will make findings of fact and then vote to either approve the application, deny the application, or approve with conditions. An affirmative vote of at least 3 members is required for approval. All right, so I mentioned we had 5 individual parts to the preliminary matters. The first one is the use of alternate methods, alternate members. We have 2 alternate members currently, Steve Beveridge and Creosote Rowe, and I would like to open for a motion to elect both members, if I can do that at the same time, both members from alternate status to full membership status. Let's see, I need,
So moved. You have a motion.
Steve
do I hear a
Beveridge,
second?
Steve Beveridge, I need to unmute yourself. I'm trying to unmute you.
Are you there, Steve?
Can you hear me now?
Yeah. Did you catch the motion in the second?
There was a motion and a second.
Okay. And we're voting regarding the alternate status of Steve Beveridge and Teresa Renault. Excuse me, Rowe. All right, so we have a motion, we have a second. All in favor? Is this how you vote? I guess so.
You should do a roll call vote, John.
Okay, thank you. John French, we're not gonna hear from him, I don't suppose. Ron Van Ostel. Ron Van Ostel. How do you vote?
Yes,
You're coming through kind of murky, Ron.
yes,
Thank you.
Yes.
Steve Beveridge,
I know, I have slow internet speed.
Riso,
Aye.
Audrey,
Thank
what that noise is.
the motion has been seconded and approved. Welcome, Steve and Riso, you're now full members. Now, moving on, the second of the 5 items, we need to establish a quorum. And since we have 3 or more, we have satisfied that condition. A third item regarding that belongs with the preliminary matters. The timeliness of appeal, the complete application and fees submitted as called out in Article 5, Section 5 of the ordinance. Notice of this public hearing was published to the Camden Herald on June 25th and April 30th, 2020. And also the appeal was noted on April 30th in a letter in May 14th at the latest. Wait, I'm sorry, I got to start over again with this. I butchered this terribly. Notice of the public hearing was published in the Camden Herald on June 25th, April 30th, 2020. A letter and those 2 days. The letter from the CEO requires an appeal within 10 days of the 4/30/2020 letter or by May 14th at the latest. We believe both of these conditions are satisfied. Moving on.
Wait, before you do that, John, let me just say something, and then I think you should take a vote as a board that the appeal is timely. And you'll need to do it as a roll call vote. What I'd like to say about this is that it's clear that the May 13 letter would not normally have been timely, but circumstances obtained with this particular appeal involving circumstances beyond the control of the appellant and of the abutters council to be in a position to have the appeal heard earlier. And so by virtue of an April 30th letter, the code officer in conjunction with town staff said, as long as the appeal was filed at the latest by May 14, it would be timely. The board needs to specifically say that because the appeal was filed on May 13th before May 14th deadline, that this appeal is timely. So there needs to be a ruling, because if we don't have a timely appeal, we don't proceed. So if we're going to proceed, we need to have a vote of the body by at least a majority that this is a timely appeal. I believe, based upon the circumstances, that it is a timely appeal, but I'm not a voting member. So someone needs to queue up a motion for the chair.
Would someone please make a motion to that effect?
So moved.
John, this is Ron. I make the motion that we accept their appeal as a timely appeal.
There you go.
Second.
And a roll call vote, John.
Let's have a roll call vote. A hand raised can do it, or do we have to go around?
Go around.
Okay. John French, there yet? Ron Van Ostal,
Yes.
Steve Beveridge? Steve?
Yeah.
Creasel?
Yes.
John Cool votes yes.
So can we try a show of hands with John French? Because we don't want to leave him out of this proceeding if he's going to be voting at the end of the evening. So John, Cool, could you just ask John French to raise his hand so we can see if he's raising his hand, yes or no?
He's not
John
here.
French, can you hear us?
Oh, he's not there now. Okay, fair enough.
Is he in
He's
group
headed to the
comment?
town office perhaps. Okay.
Yeah, I think so.
All right.
Andy.
So you do have at least a 4-0 vote. We might want to ask
Cool.
John French when he's back on how he votes on timeliness.
Yeah.
Okay.
So
Okay
we
to
have-
proceed, John.
Okay. The next item under the preliminary matters is a jurisdiction to hear appeal. Again, I have to read that the jurisdiction is provided under 30-A MRS section 269, and also item number 2, the Article 5, section 1 of the Canton zoning ordinance, which provides the action of the code enforcement officer issuing a notice of violation or similar notice shall be appealable to the zoning board of appeals by an aggrieved person or party within 15 days after the date of receipt of notice. Continuing
I
on,
think that's sufficient, John. You don't need to read the rest.
okay, there's a lot more that we think we've established a jurisdiction.
In my opinion, because this is a legal issue, I'll give you my legal recommendation, but it's up to the board to vote this. Because Article 5, Section 1 is so terrifically clear that the action of the code officer issuing a notice of violation or a similar notice shall be appealable to the Camden Zoning Board of Appeals by an aggrieved person or party. That meets the jurisdictional requirement. So I find from a legal matter that there's jurisdiction, but the board needs to make the ultimate determination as to whether the board has jurisdiction over this appeal.
All right, thank you, Andy. The last of the 5 items is the type of
You
review.
need to take a roll call vote on that as well, sorry.
Okay. Again, Ron, can you make a motion?
Yes, I make a motion that we have the jurisdiction over the appeal.
I need a second.
Seconded.
John French, how do you vote? Ron Van Ostal, how do you vote? Ron? Hello, Ron.
Yes.
How do
Yes,
you vote? How do you vote, Ron?
yeah, I agree, yes.
Steve Beveridge, how do you vote?
Yes.
Chriso?
Yes.
John Cool votes yes. Moving on to the type of review to be conducted. This is a de novo review. Again, I'm going to read to you. You are required to review this application de novo as found in Article 7, Section 3, Section 3, parentheses 9. This section should be sent into the record as well. Excuse me. To decide an appeal of a decision of the code enforcement officer or the planning board as an administrative appeal from a decision pursuant to the wireless telecommunications facility siting ordinance when it is alleged that the decision is based on an erroneous interpretation of the ordinance. The review of the zoning board of appeals shall be based exclusively on the record before the planning board. An appeal of a decision of the code enforcement officer shall be de novo, meaning requiring an evidentiary hearing.
So I think that's sufficient to discuss that particular item. And whereas the prior matter, the board had to determine that it had jurisdiction over the appeal. I think that because the ordinance is clear enough that an appeal of the code officer's decision involves a de novo appeal, that's decided as a matter of law by the ordinance, and the board doesn't have to make a decision, because as the law court has said, the ordinance simply needs to give direction as to whether it's de novo or purely appellate. Your ordinance says it's de novo, so that won't require a roll call vote and doesn't require anything further. That'll take you to your next item, John.
Okay, the next item is the standing of the appellant. Evidence will need to be submitted that the appellant will suffer, quote, particularized injury, unquote, such that it has standing to pursue the appeal. The essence that the applicant has at stake in the outcome of the appeal. And also I need to read, when a person can demonstrate that he or she has suffered or will suffer a particularized injury as a result of a decision by the planning board or CEO, she has met one part of the general test for standing, end quote. To file an appeal with the Board of Appeals, if the board has jurisdiction to hear the appeal by ordinance or statute. To meet the particularized injury test, the person must show how his or her actual use or enjoyment of property will be adversely affected by the proposed project and must be able to show some other personal interest which will be directly affected, which is different from that suffered by the general public.
I would through the chair pose a question to the appellee, the code officer, and then I'll pose the same question to the abutters council. Steve and Bill Kelly, do either of you have any concern or objection to the standing of the appellant?
Steve, do you have any concern or objection?
Bill here. I'll just say this, that it appears that the homeowners association has legally dissolved. However, there is a statute that provides that for legal matters, the homeowners association or a dissolved corporation may conduct such businesses as necessary post dissolution. So there's no objection from the code enforcement office that the appellant has standing.
So just again, through the chair, I'd pose a question to Attorney Rutter. I had heard that the homeowners association had been dissolved. What's your perspective on your status, your legal ability to participate in this proceeding? And then secondly, do you feel that there is adversity in this case and that you will suffer particularized injury? So Attorney Rutter.
Sure. I would echo basically what Bill stated. That this is a situation in which, though the homeowners association dissolved, there could potentially be a decision from this board, which would require the wrapping up of certain business that the homeowners association was involved in. And as a result, there is, would be standing, and particularly as the receiver of the notice of violation. As to particularized injury, that again, as the entity against whom the notice of violation was issued, I believe that's sufficient for standing.
So
there's another paragraph here to go through.
Yeah, no, I don't think it sheds any greater light on the basic question of whether there's standing, because there's participation. And so that's why I asked the question about particularized injury. So I think on the two legal standards for standing for zoning purposes, such as we have here with a zoning enforcement action, a subdivision enforcement action, there is a statement as particularized injury, and there's a statement as to intention to participate. The board, I think, should decide the question at this point in time, whether or not the appellant has standing, or you could reserve it after hearing more evidence. I'm not sensing that the principal parties are objecting. I would recognize through the chair, Attorney Gibbons, and find out if he has any objection to the standing of the appellant.
I have no objection.
Okay. So I think that provides the foundation for the board. You've heard that neither the appellee, the code officer represented by counsel, nor the abutter represented by counsel has objection to the standing of the appellant. My advice is there's been a sufficient threshold statement that could be challenged later in this proceeding. I don't think so based upon what I've heard. So I would recommend that the board determine whether the appellant has standing. And my recommendation is there's been threshold information that would provide you with the ability to find that there is standing by the appellant. But that, again, that's the board's determination.
Okay, Ron Van Ostall, you
Yes.
there? Can you make a motion regarding the standing of both parties?
I make a motion that both parties, all right, I mean,
Regarding standing,
that both have standing, and the Board of Appeals has to hear both parties.
do I hear a second?
Second.
Thank you. How do you vote, John French? Ron Van Ostall, how do you vote?
Yes,
Steve Beveridge,
Yes.
Chris O'Rourke,
Yes.
John Cool votes yes. That should be sufficient.
That is.
Okay. Last item. Well, no, I'm sorry. No, excuse me. All right, so now it's my turn to summarize the appeal. I'm gonna do some more reading here, folks. Simply put, the notion of violation states that the long-term management of the 3-acre reserved green area and detention pond property is important to the health of the McClintock watershed. We will need to understand more about that. All facts of this management issue are what the Camden Zoning Board of Appeals will hear, evaluate, and discuss. Finally, after hearing the facts from the parties and those interested persons who may be given authorization to present their statements, the board will deliberate and may then address the asserted violation itself and perhaps even some direction toward resolving ownership and subsequent management of the reserved property in question. So let's begin with the first presentation.
I would just ask that, I know that there is a waiting room full of individuals who are lot owners for lots 68 through 79. And I'd just be reminded of what the procedure is for them to be able to participate.
We have them here on the docket on the sequence of presentations.
Okay, and at what point will they be brought into this meeting in this in this format?
They will be, hold on a second here. Jeannie, can you help me out here a second?
Yeah, I can step in here, John, if it's helpful to you, Ms. Andy. So I do think that unlike parties and the immediate abutter who is involved in the sale transaction, who are already in and the board has determined that they're standing, you now need to decide which, if any, or all of the parties who've sought interested person status will be granted that. The determination of who is an interested person is whether they have an interest that is relevant and specific to this proceeding. If somebody wants to talk about whether the sky is blue or gray, not an interested person. If they want to talk generally about how subdivision violations should be prosecuted in the town of Camden without reference to the specifics of this case, very interesting, but they're not an interested person. On the other hand, if they hold a property interest that is proximate to the reserved green area and detention pond lot, if they have something very specific to say where they're going to provide factual evidence that is not immaterial, irrelevant, or unduly repetitious, I think generally boards of appeal allow folks to speak. And then there's the other category of the public. The public are going to participate through YouTube and be able to offer questions, as I understand it, John. So I think as chair, you ought to queue up the question of your colleagues. Who's on the list of folks who want to be considered to be interested persons? We ought to make sure we have a complete list. And I wouldn't try to decide this one by one by one. I'd get the entire list in front of you and have a motion as to all, unless there's some inclination to exclude some. But for motion and then the discussion, where you could then parse the list, it'd be helpful to have a list from either Jeannie or Audra or whoever else has been keeping the list of interested persons to provide that to you. Maybe Jeremy has that.
Well, we
May
have,
I, excuse me, there is a list of the people who've requested to participate behind the agenda.
yeah, I have it here, Jean.
Uh-huh,
Yeah.
okay.
But before we get that far, we have Steve Wilson giving us a summary.
Would it be beneficial to amend the agenda to get the interested parties in so that everybody hears the same information?
Sure.
That's fine. That can work.
See why not?
Yep.
So now we will consider the consideration of requests to participate as an interested party. Each individual will need to come forward and inform the board what their connection is to the property. And as Jeannie said, we do have a list of people here who have indicated they would like to do that.
John, really
Yeah.
quickly. This is Jeremy Martin, Planning and Development Director for the town and co-host of this meeting. So I see 5 people that are in the waiting queue. I believe all are subdivision lot owners, as Jesse prescribed, other than Bob Perkins, who is in a butter across the street from the detention pond. Is that correct?
I have the 5 plus Bob.
Oh, okay, so someone on this, someone must not be participating right now, Jesse, that
Maureen Peabody, I believe, is listed as an interested party. She is in my office. She is
Okay.
the former president of the HOA.
Okay.
Will she be participating, Jesse, as an interested person?
If needed, I don't anticipate so, but
Okay.
if the board is going to rule on everyone else, they might as well rule on Maureen as well.
What I would suggest is Andy, and maybe you can advise the board on this for, again, trying to do this in one fell swoop. You've got 6 people total. Oh, someone just left the waiting list. So I don't know who that is. Oh, someone got in and they're out.
So let me just read the list and let's just see if we can confirm that these folks may be present.
Okay.
So the list includes Robert Perkins. We've just addressed with Jesse's help, Maureen Peabody. The next is Darby and Katie Uri, and I remember seeing Katie Uri. Allison and Vincent Contento, Matt Flick, and Edith Cohen. And out of those, is there anybody that's not in the waiting room or not looking to speak tonight?
Andy, I would say that I see a 603 phone number and I'm not sure who that is.
Can you unmute that person so that they can indicate who they are?
I guess I'm going to admit them for the moment.
Yep.
603, can you please identify yourself? All right. You know what it may be? Is Matt Flick from New Hampshire and have a 603 phone number?
For the individual that's just been admitted to the proceeding, you have a 603 number, which is a New Hampshire extension. Can you identify who you are?
Being on many of these Zoom meetings before, I've had to use multiple devices. I believe, Jeannie, if you can go back through that email list, I think M. Flick has a New Hampshire phone number.
Sure, that's Matt Flick. I'm trying to figure out how to get in, so I'm on both the phone and watching you live.
Okay. It's exactly what I thought it was. 603 is Matt Flick. So we've got 5 people in the waiting Now the rest are
Yes.
members and one Bob Perkins.
You have a 603 number, which is New Hampshire extension. Can you identify who you are? Oh, there's the delay feedback, Jeannie. You may want to mute
Yeah.
yourself.
That actually, I think, was Matt.
Yeah, that's Matt Flick if he's on 2 devices.
Yeah. Okay, so Matt Flick, I think we've got a sense. Jeremy, you've got the assessor's records, or you've seen those. Is Matt effectively in a butter to the parcel in question?
I don't have the exact parcel numbers and the map and lot ownership in front of me. I do remember speaking with a gentleman from New Hampshire who owned, I believe, 2 lots. So I believe that is Matt Flick on this. So I believe so, yes.
I'm going to make just a process suggestion, and that is we need to let the folks in to make sure that we understand their status with respect to the property. And
that's fine. I will let all those people in right now.
Yeah. So just to help manage this, John Cool, what I'm going to suggest is that we just get folks to acknowledge that they're present. So I'm going to go back through the list that has been provided by Gene. One individual is Robert Perkins. Are you there, Mr. Perkins?
Yes, I am, but I'm also on the YouTube, so I'm all double teaming here. Let me kill this.
Okay.
Edith, I'm going to ask you to mute yourself, please. For some reason, I can't mute you.
There you go. So, Mr. Perkins, do I understand correctly that you own property in the area of the reserved green area?
Yeah, if I could just, the detail is that our property is directly across the street from the detention pond, especially at the end of the pond that has the big tube with the holes in it, lets the water out, and then the water goes down to the side of the road directly across the street from us, and then it goes under the road in a culvert and comes out on the western side of our property and runs over our property down to the river. When it runs normally hard in the winter, that's like a fire hydrant has been let loose. But at some point in the past, just at some point before we bought the property and built on it, the berm failed and the water came across the street uncontrolled and across our property. So those are the big reasons why we care about this.
Yep. So that's the specificity I was addressing earlier. That's helpful. Mr. Perkins, thank you. Matt Flick, what is the nature of your interest? And then we'll go to the Uris. And I think Katie Uri was on. You still there, Matt? While he's managing his device, is Katie Uri present? You're muted, Katie. Can you unmute?
I'm working on it. Sorry.
Okay, no worries.
Katie, I just asked to unmute you, so you need to acknowledge that. There you go.
Since we know the Contentos are on, can you? They're unmuted. Could we have just the Contentos speak to this now? Then we'll come back to the Uris. Where's your property, and do you have a specific concern with respect to the reserved green area and detention pond property?
We live at 73 Goodwin Lane, and we're part of the PRHA Association. We live just up the road from the green area, and we have a vested interest of understanding, what the town has to say about the what we want to do with it, and what's the next steps for either parties and the direction we want to go overall, but nothing specific at this time.
Thank you. That's helpful. And I believe the Uris are on now. So Darby and Katie, what is your property's relationship to the subject property? And do you have a specific concern with respect to that property?
Sure, thank you. We're 39 Goodwin. We moved in kind of after all of a lot of the history occurred here after the property was transferred to the Corridas. We're looking at the green space as we sit here, and it abuts our property, and we're very interested in making sure it stays green space. And we're also very interested in the retention pond, and making sure McGunnacook is kept clean and that is updated as it should be and kept regularly maintained. So we'd love to see it continue to be green space, and have met with the Caritas and understand what their intentions are, or believe we understand what their intentions are with respect to the lot.
Okay. And at some point, we need to hear from Mr. Flick again as to the location of his property proximate to the subject property and a specific consideration he has with respect to the reserve property. Let's go to Edith Cohen while we seek to free up Matt Flick to speak to this. So Edith, are you proximate? Is your property proximate to the reserve property? And do you have a specific concern? You're unmuted, Edith, so go ahead and speak. Edith, you're not muted, so I think you can speak. She perhaps can't hear. So there you go. Edith, can you speak to your property's proximity? She's not hearing me.
She's not hearing you, I know.
Yep. Mr. Flick, are you there now?
I am. Am I coming through okay?
You are.
Yes.
All right. I apologize.
No worries.
Can you explain your interest?
Sure. I'm an owner of lot 71 and 72.
And are they proximate to the reserve property?
They're approximate in as much as any of the other neighbors in the development is. Yes, I'm part of the formerly homeowners association as I'm sure the other interested parties that I was having trouble hearing, but the Contentos, the Edith Cohen next door, and the rest of the neighbors. I'm right in the middle of everybody.
Okay. And so with respect to this proceeding, do you have a specific consideration that you don't need to offer now, but I'm just wondering if you've got a specific issue for this proceeding?
I
Yes.
do. I'm very hopeful that the board will vote in favor of Attorney Rutter's position representing the rest of the homeowners, and to remove the notice of violation so we can continue forward with the previously intended disposition of this parcel.
Okay. And Edith, are you available to speak now? I can't tell Jeremy whether she's
I think
hearing
she's
us.
I don't think she's hearing us.
Okay. All right. So I think
I'm hearing everyone else.
What I'd recommend to the board is that you find that Mr. Perkins, the Uries, Allison, Vincent Contento, and Matt Flick have met the test. And I suspect, based upon what Mr. Flick just said about proximity to Edith, that she's proximate. I don't see any advantage to be gained by excluding her from the ability to speak during these proceedings if she's able to work the technology to be able to speak. So that would be my recommendation as counsel for the board, is that you allow these folks into the proceeding and allow them to speak when it's time. They'll be subject to whatever rules the chair and the board apply to the participants, but I think you should allow them in. So now to you, John.
Yeah, Ron, can you
May I just add that I've checked our assessing tax rolls for all 5 of these people, and they are all shown as current owners of the properties, as they say.
Thank you, Jeannie.
Ron Van Ostall?
Yeah, this is Ron.
Can you
John,
make a motion to the interested parties?
Can you hear me, John?
Can you make, yeah, I can hear you. Can you make a motion regarding the list of the interested persons just
Yes.
reviewed?
Shut up and let him.
I make a motion that the interested parties on the previous mail we received be identified as interested parties and approved to speak.
Do we have a second?
Second.
John French, how do you vote? Ron Van Ostall,
Yes.
Steve Beveridge,
Yes.
Chris O,
Yes.
John Cool votes yes. Okay,
So the board has determined that those 6 listed parties in Gene's list, as requesting the opportunity to the board, consider them as interested persons, they're now approved as interested persons. So now it's back to you, John, in terms of the sequence of presentations.
thank you. Okay, here's the sequence of presentation and the time allotment. First, we'll hear from the appellants and the appellant's attorney, and we will do so without interruption. The submissions will be entered into the board. And, you know, actually, let me back up a second here. We put off Steve Wilson before. He wanted to give a summary after the interested parties were established. Now, I wonder if Steve would like to do that now, or does he want to skip that? We had that
No, I think
as an option.
I believe that would be helpful if it's okay with the chair.
The chair recognizes Steve Wilson, CEO Camden.
Okay, the background on this property, as everybody knows, has been a multi-phased subdevelopment. In 1985, they ended up having to go get a stormwater permit because they had exceeded the site location law for the state of Maine, which is when the detention pond on that green space actually was established, was during that 1986 approval. From there, there were additional developments and improvements that also shed stormwater to this parcel from the last phase, which is where the homeowners association got tasked with maintaining that lot. That was done in the 1996. We received notice they were looking at selling that lot for possibly not having a maintenance agreement on it per the HOA as required by our subdivision approval of that phase of the development. So we reached out to them, tried to work with them to come to a different solution. The lot ultimately got sold, is no longer in control of the HOA, which is a violation of the approval because it was not an approved lot for sale. It was approved as being part of retained green space for the homeowners association. So it's the town's stance, or my stance, that as this has been sold out of the subdivision and out of the criteria of the approval of the subdivision, that lot owners are in violation of that final approval.
Okay.
Mr. Chairman, this is Bill Kelly for just a second to say that we'll go through the notice of violation in more detail later, but I understand that at the moment, the CEO is only giving a brief overview and that we'll participate after the appellants in terms of providing our evidence.
You assume correctly. Okay, back to the sequence of presentations. So we will hear from the appellant. They will be allowed 15 minutes. Again, they will do so without interruption. Their testimony will be entered into the record. The board, through the chair and from the CEO and interested persons, may ask questions. Again, 15 minutes for that. Following that will be the appellee's presentation. Same drill, really, without an interruption. Be entered into the record, and questions from the appellant and the board can be made through the chair. And at that point, it does not allow for interested persons to ask questions of the appellee's presentation. Following that, for 5 minutes, rebuttals will be allowed by both parties. 3 parties, actually. Following that, there will be public testimony by interested parties and via YouTube comments. And the interested parties have already been established. Then we'll have 2 rounds. The first round will be from the public. And that'll be 2 minutes for each person coming forward. And comments and questions will be addressed through the chair to each member of the public. After the presentations, we will have a second round. We'll have comments again from the public, 2 minutes apiece, comments and questions from the board. Following the end of the second round, we will close the public hearing. At that point in time, only the board will be allowed to deliberate. There'll be no more questions or presentations. So that being said, let me offer a word to the board members. Let's make sure that while we're going through these presentations, that we are taking very good notes, preparing for our discussions, and of course, preparing for questions to ask during each of the presentations and also during rebuttal. So with that, I welcome the appellate. They are recognized by the chair.
Thank you very much, Mr. Chairperson, members of the board, and I appreciate everyone in attendance for taking the time out of their day and their evening to hear what we have to say. I do think a little background is important. I think we don't know why we're here unless we know how we got here. So to put a little bit more meat on the bones of what Steve had mentioned about this subdivision, Pleasant Ridge is a multi-phase subdivision, the timing of which is spelled out in the materials that have already been provided. It contains 79 lots. It is one subdivision, just one. There's not multiple divisions. This is one subdivision. It's completed in 5 phases beginning in 1982. The final phase, phase 5, was approved in 1995. In 1986, a detention pond was created as part of a stormwater management system. That detention pond was positioned in an area outside of lots that had previously been approved by the town. Later, in phase 5, which was approved in 1995, the final 12 lots were added to the subdivision. These 12 lots encompass the geographic area where this detention pond was created. This pond became a separate lot, which for convenience sake, I'll refer to as the pond lot for the balance of my presentation. These 12 lots that were part of phase 5, or encompassed all of phase 5, were lots 68 through 79. I'm not going to bore the board with the mechanics of how this occurred, but through a series of conveyances and modifications to restrictive covenants and maneuvering by the developer of this subdivision, the owners of lots 68 through 79 were made solely responsible for the maintenance and care of the detention pond and the pond lot. No other lot owners were made responsible for that. So through the conveyance, and this was accomplished through the conveyance of the pond lot to an HOA that had been created by the developer with no members in it, separate and apart from the HOA that had already existed for the other 59 lots that existed at the property. What was the effect of this? Well, the effect of this was the responsibility, the sole responsibility for maintenance and upkeep of this detention pond was left to these 12 lot owners. These 12 lot owners and these 12 lots don't use the detention pond. Their stormwater does not go to this detention pond. The other lots, phases 1 through 4, their water goes to this detention pond, and yet through this maneuvering, they have no obligation to maintain or in any way contribute to the cost of upkeep for the detention pond lot. It's certainly an inequitable result, and it's made even more egregious by the fact that the lots 68 through 79 owners had no say in this. This was all done before anyone came to own these lots. Additionally, no adequate financing was provided to the HOA by the developer to carry out this responsibility. Basically, it was, I'm creating an HOA for these 12 lots. You're going to have to join this HOA. And by the way, you're responsible for the detention pond. And here's no money. The HOA has been burdened with this inequitable obligation that they never had any say in, and for a system that doesn't serve them. 12 lot owners who never had a say have been saddled for years with the costs of maintaining the detention pond and insuring the pond lot. I note that one of the conditions that was imposed upon the developer for this phase 5 by the DEP as part of their site location order in 1995 was the creation of an emergency spillway for the system. This was finally accomplished in 2010. It was solely funded by the 12 lot owners of lots 68 through 79. No one else. Developer didn't pay for it, just the lot owners. With all this as a backdrop, you can understand, I hope, why the owners of these 12 lots feel a bit marginalized, feel that they are being burdened with an obligation that should not be theirs. So the HOA has began to explore ways of alleviating themselves of this burden. I would point out that at one point, it was during a select board meeting back on October 8th of 2019, that Mr. Martin had said, HOAs don't typically have the technical know-how or understanding of what a detention pond is or how to maintain it. That's exactly it, is they don't, and they shouldn't be forced to bear this burden for a detention pond that they simply don't use. So with the assistance of counsel, Ed Collins, former attorney in my office who was unfortunately passed away, the HOA explored the viability of converting this lot, the pond lot, into a building lot and selling it. Let me preface this all by saying this was never done. The lot was never converted into a building lot. This was simply an avenue that was being explored by the HOA as a way of alleviating this, again, this inequitable burden. So discussions were had with the DEP as to the next steps or what steps will be required to do that. How could this be accomplished? Because obviously stormwater management is within the purview of the DEP. And at no point in those dealings with the State Department of Environmental Protection was our office or representative of the town told that this pond lot cannot be conveyed from the Homeowners Association. That was never said to anyone by the DEP. In fact, Dawn Hollowell, who is the Regional Licensing and Compliance Manager, Land Bureau for the DEP, said in an email dated August 23rd, 2019, I'm not sure the regulations care who does it, as long as the maintenance is spelled out and a schedule is submitted and the responsible person actually does it. Nowhere does it say that that has to be the HOA. Nowhere. Mr. Martin, again, at that same select board meeting on October 8th of 2019, in response to a question from the board, when asked whether what the DEP's position was with respect to conveying the lot, stated it was his understanding that the DEP does not care who's responsible as long as it is in the deed that says who is responsible to maintain it. So with this guidance from the DEP that frankly, they don't care who does it as long as somebody does it, a meeting was held of the HOA on October 9th of 2019. And there had previously been discussions about what to do with this pond lot. And prior to the October 9th meeting, a letter of intent was received from attorney Jack Sanford from Camden on behalf of a client who had offered to purchase this pond lot with the express purpose of maintaining it as green space. The letter of intent specifically spelled out that this individual understood that they were responsible for the maintenance and upkeep of the stormwater management system, the detention pond, and that they would comply with all of the requirements set forth in the DEP site location plan. That was presented to the Homeowners Association. During the course of the discussions, Michael and Christine Carita, who Michael is present, they are one of the two properties that abut this pond lot. And what they did was they expressed a preference to be the ones to keep the lot, to have the lot be conveyed to them as opposed to conveyed out or to somebody else. And basically, it was only after, not basically, I shouldn't characterize it that way. Explicitly, it was only after discussion was had in which it was made clear to the Caritas that they would be bound by the same terms as were contained in the letter of intent, specifically that they would have to maintain and keep up the stormwater management system, keep up the detention pond, that this would be their responsibility. They would have to comply with all of the DEP regulations and DEP guidance set forth in the site protection plan, or site location order, excuse me. It was only after they conveyed to the HOA that they were willing to take this property under those terms did the HOA agree to convey the pond lot to the Caritas. So a deed reflecting this conveyance was recorded on October 10th, 2019. Pursuant to the DEP's instructions, language regarding the maintenance and upkeep of the drainage system and the detention pond were put directly into the deed, and you do have the deed as part of the materials that were provided to you today. On October 28th, 2019, the HOA received the notice of violation, which indicated that the conveyance of the pond lot was a violation of Subdivision Ordinance Article 8, Section 15, Subpart B9. Following receipt of the violation, the HOA continued to communicate with the Caritas and specifically with Caritas counsel, Mr. Gibbons. And it was discussed continuing with the conveyance of this pond lot to the Caritas. In November of 2019, an agreement was reached in principle with respect to how this would be accomplished, which with the other HOA lot owners making a one-time contribution toward the current maintenance, to bring this pond lot up to current maintenance standards. It's my understanding that the only thing that held this up was this notice of violation, and that the Caritas understandably were unwilling to undertake this obligation and move forward and finally put a resolution to this with this notice of violation outstanding. So here we are today. I would just like to read, if I could, the violation, the provision that the notice of violation contains. Specifically, it states that the developer shall maintain all components of the stormwater runoff system until the system is formally accepted by the town, or is placed under the jurisdiction of a legally created property owners association whose character and powers require maintenance of the system with adequate financing to carry out this responsibility. That is the entirety of that provision. Nowhere in the subdivision ordinance, whether it be that provision or anywhere else in the subdivision ordinance, does it say that the HOA cannot convey the pond lot. There's nothing that says once it's in the HOA's hands, it's a black hole of responsibility that cannot be conveyed. That's nowhere in anywhere in the subdivision ordinance. Nowhere in the subdivision ordinance does it say that responsibility for the upkeep and maintenance of the stormwater management system can't be assigned to somebody else. Again, that this is a black hole of responsibility to an HOA that doesn't even use the detention pond. There's been some discussion and correspondence exchanged among the parties that an amendment to the subdivision would need to be approved in order to do this, and that this could accomplish the goal that we have here. But nowhere in the approval or in the materials provided to our office does it reflect that the pond lot had to be held by the HOA. It's just not simply in anything that I've seen in connection with this matter.
Jesse, can I interrupt you for a second?
Sure.
The chair would like to extend another 5 minutes. Would that suffice?
Thank you very much. I anticipate only needing about one, but thank you, I appreciate it.
You're doing fine, thank you.
Thank you. I would point out that the conveyance of the property, the pond lot, to the Caritas is not a change in use of the lot. I think there's been some confusion perhaps because there was discussion at some point about converting this lot into a building lot. That's not what this does. The Caritas have agreed to take this property as is and to maintain it as is in its current use, undertaking the obligations that the HOA previously had with respect to this lot. Specifically, the deed states, this is the deed from the HOA to the Caritas. It is understood that they will assume all responsibility, liability, and financial obligation for the ownership and maintenance of said drainage system and detention ponds located on the subject premises as is required by the Maine Department of Environmental Protection site location order. So basically the deed says exactly what the DEP wanted us to put in the deed. The DEP doesn't require that the HOA maintain and hold on to the pond lot or be the entity that manages the stormwater management system. There has, again, been repeated reference to standard condition number 5, which was part of all of the DEP site location orders, but specifically as relates to this area would be from 1995. And I would just read that into the record just for clarity, that the standard condition number 5 says, unless otherwise provided in this approval, the applicant shall not sell, lease, assign, or otherwise transfer the development or any portion thereof without prior approval of the board, where the purpose or consequence of the transfer is to transfer any of the obligations of the developer as incorporated in this approval. Such approval shall be granted only if the applicant or transferee demonstrates to the board that the transferee has the technical capacity and financial ability to comply with the conditions of this approval and the proposals and plans contained in the application and supporting documents submitted by the applicant. That provision, by its plain reading, applies to the applicant. The applicant in this situation is Monroe and Goodwin Real Estate, the developer. It's not the HOA. The HOA was not involved in any respect in the application process. Now, one wonders whether the developer obtained board approval when he transferred this lot to an HOA that had no membership and with no financial backing in 2002. But perhaps that's a ship that has sailed and has kind of put us in the position that we're in now. To sum up, it's my position that the notice of violation should be vacated and dismissed. The conveyance of the abutters doesn't violate the town subdivision ordinance. The HOA should be able to proceed with the conveyance to the Caritas under the terms of the agreement reached in principle back in November. Thank you very much.
Thank you, Jesse. Now the chair will entertain questions from the CEO.
One question I have is, our ordinance states that it has to be owned by either the developer or the HOA. That's a pretty standard part of subdivision law. The other issue is you have a detention pond that agreeably serves the rest of this development and not this development. The outlying areas of that detention pond do serve the HOA that was in control of the property. There was a stormwater study that shows sheeting action across those other sections of that lot. But also, if there is a malfunction, this pond is at the base of the rest of the subdivision. And if there is a stormwater issue and this pond needs maintenance, the rest of the association has no right to try to prevent or presume or push for that maintenance, as this is no longer owned by the subdivision homeowners association. So where do the rights come to maintain that pond, other than why would the purchaser want to maintain a pond benefiting a subdivision they're sort of part of, but not getting any financial help from?
Well, Steve, that's exactly my point, is that this conveyance doesn't change the fact that the people who actually dump their stormwater into this lot have no standing to do anything with respect to the lot. That your point highlights the fundamental inequity in all of this, is that this is an area that serves 59 lots that aren't part of the response, that aren't part of the group that is shouldering the financial burden of it. So nothing about the conveyance to the Caritas changes that.
John Cool, I have a question.
Yes. Who's
Um,
speaking?
This is Jeremy Martin, Planning and Development Director, also Assistant CEO in the town.
The chair recognizes Jeremy.
Thank you. Just Jesse, I understand and I appreciate a lot of what you said, and I do understand the dilemma that this HOA is in. I guess a question, was it when they purchased the property that they were responsible for this?
I'm sorry, you cut out for a moment. I just didn't catch the very beginning.
You mentioned that they're responsible for this and they're trying to release that responsibility for the reasons you've stated, but it is in their deeds that they're responsible for this.
It is.
Okay.
It is, but this is.
That's all I was asking.
I realized that I didn't answer a portion of Steve's comment before. I kind of answered his questions out of turn. His question was, doesn't the ordinance that's cited as the violation here, doesn't it require that either the developer or the HOA be the entity that maintains the storm management system? And nowhere in that ordinance is it exclusive. I can't speak to what other ordinances say, and frankly, it's irrelevant what other ordinances say. For the town of Camden, it doesn't say that that's exclusive. That's not in the plain language of the statute.
Okay.
One more question, John. This relates to the DEP site law permitting.
Yes, please.
Jesse, wasn't there in that 1995 permitting, wasn't there mention that, in quotes, Monroe Goodwin Real Estate is responsible for maintenance of common areas until year 2002? At that time, a homeowners association established through deed covenants will be responsible for common areas?
And that's true. And there were a number of lots. In fact, most of the lots that comprise 68 through 79 hadn't been sold. So he basically conveyed it to an HOA that had no membership.
I understand. I'm just trying to, you mentioned DEP's permitting standard condition 5. I also want to ask that question about what was also included in that permitting document, was that Monroe Goodwin was responsible for maintenance of those areas until 2002. After that, and this was in the DEP permitting, an HOA established through deed covenants will be responsible for the common areas. That's all.
It does state that. However, it does say it's under the own ordinance that the town is citing, says that it has to be conveyed to an HOA that has the financial capability to do it, as based upon funding received from the developer. That just simply didn't happen here because it was an HOA with no membership.
Understood. And one more question, maybe, if I don't mind.
Yes.
If the HOA through deed conveyance understood that this was their responsibility, did the HOA think about, well, we've got this responsibility and it says we need to be fiscally responsible, should we be?
I can't speak to what individual lot owners thought about it. I can only speak to what the inequities of the situation and in terms of the conduct that led to the issuance of the notice of violation, simply what the tack that they took to address this situation.
Okay.
All right. Now the chair will entertain any questions from interested persons.
John, I think Steve has one more question.
Oh, I'm sorry. Steve, the CEO? Yep. Chair recognizes the CEO.
I'm trying to unmute him.
Well, he's
Jeremy,
working to.
you were fighting me because you were muting me when I was unmuting me.
Oh, there you go.
Chair recognizes Steve.
Yeah, apparently the way that went through, and then I'm just surmising on this, but if the lots were still owned by Monroe and Goodwin, then Monroe and Goodwin was in essence the HOA. Ownership of the lots constitutes membership in that homeowners association. So there was not an association with no members. It just had one continuous member for all the lots, which was back to the developer. As the lots were sold, those entities that bought the lots became members of the HOA by default. So it's not truly accurate that the HOA had no members. It was Monroe and Goodwin. They had the financial capability.
Right, in the title owner and a developer who had no intention to, as a developer, to hold these lots in perpetuity. He wanted to sell lots to purchasers and give them, and unfortunately they were then given no option to join any other HOA because it had been created. And frankly, they were put in a position where these 11 lots were paying, freighting the bill for the other 59. I can't
agree
speak
it
to,
was a
I
raw
can't speak to
deal,
the
but-
motivation for that, but that's the result.
So, Mr. Chairman, this is Andrew Hamilton. As advisor to the board, I've got to be able to understand the parties' arguments as to the application of the legal standards in the ordinance to the facts. And so I'll have some questions. You had skipped over questions from board colleagues and from council. I'm happy to allow to have you ask questions as to whether the interested persons want to ask questions, but you'd skipped over the board as the first group that would have questions. And at
Yes,
some point, if you'll come back to me, I'd like to pose some questions to Attorney Rutter. I just need
Okay.
to understand some legal
Yeah.
arguments that he made a little bit better.
I was going to allow the interested persons to ask their questions first and then go to the board.
Okay, that's fine.
Yeah.
Yep.
Yeah,
Are
no,
we
I
going
didn't
with-
skip over them
are-
intentionally. I mean, I did skip over them intentionally, but I did not exclude them. intentionally.
John,
Yes, sir.
since we have a number of interested parties, would you like to, if that's where we're going right now, let me know who you want to let in and I will let them in to talk.
Do we have all six wanting to talk, or do you have any estimate of that?
I guess maybe, let me just do it this way before I unmute people. I've got Bob Perkins, the Contentos, Katie Yuri, and then I know, and I don't see Matt Flick, but I'll unmute him because I can't see him. Can
You
we
have three or four?
we got Matt Flick, Bob Perkins, Contentos, and Edith Cohn. I'm not sure she can still hear us. I just want you guys to know who's here and let me know who you want to speak, and then I'll mute everyone else.
Okay, well,
Just to keep this efficient this evening, because we could go a long ways tonight for a very
Okay.
long time.
Yeah.
I would suggest that you ask for an interested person who has a question, because not all may, to raise their hand. I saw Bob Perkins raising his hand, so I know he wants to speak, but I think you want to ask for a show of hands. And there is a way on the participant function for folks to use a hand raise so that we can watch it and monitor it. So I just want to keep these proceedings efficient, Mr. Chairman, and you may not want to go around the horn every time just because you can.
yeah.
So,
Good suggestion with a hand raise, but also they should realize that we need to keep a time frame limit on that of approximately 2 minutes. So it shouldn't be a back and forth with each person. If they have a question, let's entertain the question and take it from there. But the question should be able to get established to Jesse within a minute and a half or 2 minutes. So do we have a first person?
We'll go with Bob Perkins. I'm going to unmute Bob Perkins at the present time.
Welcome, Bob.
So actually, this is just back.
The chair recognizes Bob for 2 minutes.
Jesse, one quick background question, because I'm confused as the status of the homeowners association. Because when I looked at the Secretary of State's website yesterday, it didn't show that there'd been any dissolution documents filed, and it simply said that the corporation was no longer in good standing. Can you provide more detail of what actually has occurred?
Thank you.
The HOA has been dissolved by inaction. There has been no annual report filed, no filing with the state. So there is a lag in terms of what the Secretary of State does, but it will be, the HOA is not functioning currently and will be deemed by the state to have been administratively dissolved once they update their computer system, but it is not currently functioning as an entity.
Okay.
Okay, thank you.
The second question is, the code officer mentioned that when Sonny sets up the 12-lot homeowners association, but he owns all the lots, so he essentially has all 12 votes. Do you agree with that?
I do think it's less than 12. I do think there may have been one or two that had already been sold, but certainly a vast majority were in Sonny's.
Right. So the bottom line is, as he sells off lots, he is still the majority person making the decisions. And then at some point he becomes the minority, but the homeowners association has lots. It's just to start with, he controlled most of them.
Right, as the developer with no vested interest in the future, it's not his, it wasn't going to
Well-
be his burden to carry for any appreciable length.
Couldn't everyone in the homeowners association put their lots on the market tomorrow? And again, we'd have a whole new cast of characters. So is that really?
Well, it's
any
interesting you
different?
mentioned that because someone has tried to put their house on the market and is running into resistance and a potential title claim because of this issue.
Right. So
Okay.
the one last question, if I could.
All right.
Do you agree that having 12 lots responsible for the maintenance of this provides more financial capacity than having only one lot responsible for it?
I don't know that I agree with that. I'm certainly not going to speak to the Caritas financial capabilities, but they have represented to everybody that they can meet those obligations.
Okay, let's move along, please.
Thank you.
We have another person who'd like to ask a question from an interested party. Any other hands?
I have unmuted Matt Flick in case he had any questions, because I can't see him.
I do have a question.
Hi, Matt. You're
Or
This-
m- m-
two
Matt,
minutes.
this was
Matt.
for
Thank
Jesse
you.
Rudder.
I'm sorry, sir, you said that my question is for Jesse Rudder, is that correct?
Correct.
Okay. Attorney Rudder, if Sonny Goodwin could own or have possession of the pond lot individually, why can not the adjacent abutter in today's date and time also take on the same responsibility of an individual owner of that detention pond?
While I appreciate the point you were trying to make, I think the distinction there is that Sonny was not operating in an individual capacity when he owned those lots. He was the developer, so the subdivision ordinance would be met because he's the developer. I appreciate what you're getting at, but I think that's the answer.
Okay, thank you very much, Matt. Any other persons of interest? Hearing none. I'd like to move.
Question,
Whoops, I'm sorry.
Oh, that might be Edith.
question. I just got
Edith,
on late
hold on,
because I was
John.
having trouble with my account and getting on. So I
John.
have no idea what happened within, until the last couple minutes.
John, just a
But,
point of order
I
really
mean-
quick. I think
Okay,
we voted on
When I
Edith
met
coming
you-
in.
when I met you at the lot that one day, you said that everything was fine, there was no problem, and that everything down there was working properly, maybe a few trimming and stuff like that. And, when I first bought my house, I had no idea
John.
even that there was an HOA and stuff, so.
John,
Yes,
John, I think Edith's directing a question to me, which is not where we are. in
well,
the
can
process.
she hear me?
Well,
Can
I because
can you
I'm new at being here, I kind of relied on you to tell me what is happening.
okay. Edith, can you hear me?
Yeah, right now,
Okay.
yes, I can on the phone.
All right. Jesse just finished his presentation and we're entertaining questions from interested persons, which you are, but we are constraining those questions to 2 minutes. So if you could ask Jesse a question and we'll get an answer and then we'll move on to the next interested party. Is that all right?
And John, just stress
Yes,
it has to be for Jesse, not to staff.
Oh, yes, and Edith, perhaps it wasn't clear with this communication business, but your question should be directed solely at Jesse. Is that
The
all right?
attorney for the
Yes.
HOA.
Okay.
Right.
Jesse, if we decide to dissolve, what's stopping it from dissolving?
Nothing. I'm not aware of any law that requires a nonprofit organization to maintain existence under these
I
circumstances.
kind of wondered because in the where I moved from, you could dissolve an HOA with a consensus of people. And, after a certain amount of time, there's no problem and no objection. Why would the town be objectionable to that sort of thing?
I can't answer that. I can't answer the question on behalf of the town. But I can tell
Okay,
you, I
Edith,
see no
thank you very much,
requirement
Edith.
that the HOA exists.
Do we have another interested party with a question? Okay, hearing none, I will open for questioning all members of the board. Who'd like to go first? Are there any questions from the board at this time?
Chairman, I have a question.
Chair recognizes. Go ahead.
Attorney Rutter, in your comments, you said that the homeowners association does not have, I can't remember your exact words, but is not an entity which has the background or experience or knowledge to manage a retention pond and do maintenance. If the homeowners association doesn't have that, what guidelines do we have that a single homeowner does? And obviously we don't need to get into any individual's financial background, but you're now putting this onto one individual, regardless of where the runoff, where the water is coming from, which lots are affected. One person is now going to take care of maintenance for something that has serious potential. And we have some guidelines from DEP for inspecting that, but that's a lot of burden for one person.
Well, I would say that my statement as to the HOA's capabilities in terms of stormwater maintenance and knowledge with respect to detention ponds was actually, I would like to attribute it to the person who said it, which was Mr. Martin. That being said, I certainly understand the concern of that. The fact is that I suspect that maintenance of a detention pond and a stormwater management system is not in the purview of many private property owners. Whether there's 11 of them, one of them, I would suspect that one would have to consult with an engineer. One would have to consult with the DEP to see what's required. Then at that point, I think it really is, unfortunately, for better or worse, just a matter of the financial obligation to do it. No one's suggesting that the Caritas are going to go in there personally and start cutting trees and maintaining the property. To the extent they have the capability to do that, fantastic. But they're in no different position than the HOA is, simply because they're one property owner and there were 10 others when it was in the HOA's responsibility.
Okay.
And on the flip side too, they would be private property owners owning the property, effectively extending the usage of their own property as an abutter, whereas you have members of the HOA who don't abut this property and are still fitting the bill for it.
Any follow-up, Chriso?
No, thank you.
Okay. Anyone else on the board?
John, I'm going to need a couple of minutes to put some thoughts together. Okay.
The chair recognizes Ron.
Yeah, I'm going to need a couple of minutes just to put my thoughts together to ask the question. Okay. I'm going to need, okay. So you go on to somebody else, but I have something I want to ask. Okay.
Okay. Jesse, I have a question.
Yes.
You've talked and in the back and forth exchange of letters and such, you've talked quite a bit about the Department of the DEP, excuse me. And you talk about them as though, to my understanding, they had primacy as far as who met the obligations for the green area and the retention. I've gotten that impression tonight as well, that you thought that they had primacy. So my question really is, at what point in time did you and the homeowners realize that that really isn't the case?
Perhaps when we received the notice of violation. I would say that if you're going to, anyone who's going to undertake any type of decision-making with respect to stormwater is going to know that the DEP, I don't know whether primacy would be the word I would use, but certainly would have a large stake in whatever is happening. As part of any, as you know, as part of any subdivision approval, there's approval that's required from the DEP, because this is a lot that contained at least, the storm water management system. That was going to be a primary concern. If we don't get permission or at least some representation from the DEP that this is even an avenue that we can go down, then we're not even going to waste our time. It was only after they made the representations to the town and to us that frankly, they don't care who maintains it as long as it's maintained, that we proceeded on the basis that we did, which wasn't until the email from DEP was August 23rd. It wasn't until October 9th that the property was conveyed.
Okay, thank you very much. Any other questions from the board?
Yes, John, this is Ron. Can somebody describe the legal options for the DEP if something happens with the retaining pond and so forth, impact on the river?
I couldn't give you a specific answer as to what the mechanism is by which they could do anything, but as it is affecting a waterway in the state of Maine, they could likely bring some type of enforcement action, whether administratively or otherwise. I can't speak specifically to that, and that may be a question that Mr. Hamilton would have more insight to. But the DEP, to my knowledge, wouldn't make a distinction on the enforcement action if the property is held by an HOA as opposed to an individual owner. And just as much as if I used my property and wasn't doing what I was supposed to and started polluting the Guntucket River, they would come after me individually.
I understand that. And so my question really is whether it's an HOA or whether it's an individual owner who owns the property. What are the legal actions by the DEP, and does the town have any legal action?
I can't speak to whether the town would have a legal action. Town could certainly bring a notice of violation as they have. I don't foresee a situation in which if there would be any basis to bring an action, enforcement or otherwise, against the HOA if they're not the owner of the property.
Follow up, Ron?
No follow-up right now.
Okay, any other board member questions? All right, thank you very much, Jesse. We'll move along.
So John?
Sure, yes. Hi.
I did have a question as the board's counsel, because I'm gonna have to straighten this out when you're into deliberations. So I want to have the opportunity to ask a question, and I'll have it for each of the appellant and the appellee.
You want to do that
Okay
now?
Okay to ask that question, John?
You want
Through
to
the
ask
board?
it? You want to ask it now, not later?
Yes.
Oh,
Yeah, I
Chair
just-
recognizes Andy to ask a question.
Okay, all right. So, Attorney Rutter, I was listening intently to your argument that would suggest that there are more than two parties under the subdivision ordinance that can hold title to a common lot. And when I look to the plain language of Article 15, Section B9, I read, the developer shall maintain, not discretionary, shall maintain all components of the stormwater runoff system until the system is formally accepted by the town. That's one possibility, the town. Or second one is placed under the jurisdiction of a legally created property owners association whose character and powers require maintenance of the system with adequate financing to carry out this responsibility. I only count two parties under that provision that can hold title to the stormwater runoff system and the property associated with that. I don't see a third in that provision. And the law court, as you know, uses rules of construction that say we first look to the plain language of the ordinance. So can I understand better your argument that something outside the four corners of that provision says that it can be
I don't think you need to
else?
look. I'm sorry, Andrew, I didn't mean to interrupt you. I
No
don't
worry.
think you need to look beyond the four corners of the statute. I think you look at the plain language, which says that the developer shall, the shall, I think we can all agree, modifies developer, doesn't modify the homeowners association. The very clear language is the developer shall, until it's placed into a homeowners association. The fact that the statute doesn't say anyone else it's the omission of language that says, and at any point the HOA can convey it to somebody else, doesn't render that not a possibility. None of the language in here says until such time as it's conveyed to an HOA, at which point the HOA shall be responsible to what, time immemorial? There's just nothing, there's no language in here that can be construed as making this as I referenced before, a black hole of obligation on an HOA. It's just, there's not
So
I think that supports that interpretation.
So I hear you to say there's a timing consideration that troubles you. So let's assume,
among others.
let's assume the timing question could be answered by this idea. It goes to the planning board and the planning board decides if it can be modified. And until it goes to the planning board, you're bound by the subdivision approval that was rendered by the planning board for the project. So how do you now defeat the requirement that if you're going to amend the subdivision, you go to the planning board? What's your argument there?
My argument is you don't need to amend the subdivision plan. There is nothing in the subdivision plan that require that this be held by an HOA. I've heard that said repeatedly, that the plan was, there's been reference to, oh, there was a note during the meeting that it had to be held by the HOA. That's nowhere in there. There's nothing in the approval documents that I've seen that conditions approval based on the HOA taking it and then not being able to convey it, and that the approval is somehow needs to be modified if the HOA wants to convey it out. I just don't see that anywhere in the materials.
Okay. I've probed sufficiently for the moment, Mr. Chair. I yield back.
Thank you very much, Andy. All right. Moving along. Thank you very much, Jesse.
Thank you.
15 minutes now will be allotted for the CEO, Steve Wilson. Steve, you're there.
I believe, Bill, did you want to start out on this or sign in on this, or how do you want to
Sure.
handle?
Yep. So, hello, everybody. Tonight, my capacity is working with the Code Enforcement Office, which means both Steve and Jeremy. And what we're going to do is I'm just going to make a couple of comments, and then Steve Wilson will go through the notice of violation in some detail so that it's clear why we're moving forward. And there'll be a couple questions for Jeremy Martin as well. So by way of, as you know, I didn't ask any questions. I'm just waited to make fairly straightforward comments. The gist of the objection from the Homeowners Association to the notice of violation is that, as we heard, the folks felt like it was inequitable and unfair that they had an obligation to maintain a drainage pond or basin that did not actually benefit their lots. And while that may or may not be true, it has no bearing on our simple premise, which is that two things had to occur in order for there to be a transfer of this green space lot with a significant detention pond on it. One is there had to be planning board approval. And the second is there had to be permission from the DEP for the transfer. One of the reasons you've all been having these questions, and there's been sort of a lengthy and detailed response from Mr. Rutter, is that it's obvious, and it's the way the law is set up, that when a subdivision is approved, there has to be somebody responsible for the common infrastructure. And while there were some comments a few minutes ago about Section 15 of the ordinance doesn't mean what it says, it means what it says. The Homeowners Association is responsible to maintain the basin, the pond. There is no other option. And we could say it doesn't say you can't give it to a cat either, or your pet dog. It doesn't matter. Those comments have no bearing on the ordinance, which is mandatory. As far as the linkage goes with the DEP requirement, which I don't understand has been suggested is not there, but there's a DEP order recorded that says that the Board of Environmental Protection must approve a transfer. That is a requirement. The fact that somebody at DEP might have said they don't really care who owns it doesn't change the fact that there's a process, just as we have with the subdivision ordinance and the requirement to go through the planning board. There's still a process that has to be followed. And the reason this sounds sort of haphazard to you folks, I think, or it does to me, is because we've taken a very routine process of using the planning board to make amendments and to make approvals of subdivisions. And instead, it's sort of been hijacked by a nonprofit homeowners association for them to decide what they're going to do and when they're going to do it and how they want to do it. And unfortunately, that just doesn't work. These are not, boards of equity where you can decide whether or not it was fair that the original folks in the upper part of the subdivision benefit from a pond that others have to pay for. Every individual in lots 68 to 70 odd, 68 to 79, they knew what they were getting into when they bought the property. It might have been unfair, but those were the rules. So that being said, I think this, from our perspective, it's a very straightforward case. I'm going to ask Steve if you would. Where'd you go, Steve? We've lost Steve.
Right, I just had to remove an animal from the room.
Oh, all right. Well, animal control. Steve, why don't we go through, if we could, want to focus everybody on the notice of violation so they can see clearly what you've stated and why.
Yeah, basically again, I think Jesse covered a lot of this. This is a 59 lot subdivision on 75 more or less acres and is under site development, site location development. And also I can address somewhat the enforcement action of the DEP. Typically they look to work in conjunction with local code enforcement when they have a violation or if there was a dumping of sludge or sediment or anything into the river. Typically they reach out and they can enforce on their own. However, they typically want to work in conjunction with local code enforcement. It just makes their job easier. But anyway, as going back to the notice of violation, it was phased in. The detention pond was built after a fact, and that took a while to get through DEP approval. This was all prior to my being there. I have reviewed the DEP orders and the stormwater system, and that entire lot is part of a stormwater system, not just the pond. The pond is taking care of stormwater from the initial 50 plus lots, but the rest of that lot is taking care of two other subcatchments, which involve the road, Goodwin Lane, and the lots uphill along that road. So those are dependent on the absorption of those waters. So there would be an issue even with clear cutting that property and trying to make a green space out of it. It would have an effect on the stormwater management plan. It's our stance, or my stance, that this subdivision was approved. It's been amended on a number of occasions. And this last amendment is the sale of a non-numbered lot, which is not an approved lot for sale under our subdivision ordinance. It's a green space. It is a detached leftover of the subdivision that is supposed to be retained by the subdivision or a HOA or some entity, however it was approved back when it was approved, or be conveyed to the town, which would actually, on a side note, make sense because the town has taken all the roads in the subdivision. So we now have a bunch of roads that dump water into this pond that we have no control over. That being said, we still maintain that the entity needs to go back to the planning board if they want to do something other than what's approved. If they want to attempt ownership in some other form, that decision has got to be made by the planning board. If they want to use that lot differently, again, that requires an amendment. It would be just like moving a lot line in that division or combining or further separating lots. Those lots need to return to the planning board for that amendment to be processed. That hasn't happened here, which is what this violation is based on. Is there have been substantial changes to the infrastructure of this subdevelopment with no board review.
Steve, can I focus you a little bit on the specific paragraphs so that we can just get through these relatively quickly? On page 2 of your notice of violation, the first full paragraph starts in 1995. There's been some testimony that suggests this language doesn't exist, but would you please explain to the board the quote that you have there and what it means?
Yeah, in 1995, DEP site law permitting indicated Monroe and Goodwin Real Estate is responsible for the maintenance of the common area until the year 2002. At that time, After that time, a homeowners association established through deed covenants would be responsible for the common areas. And our planning board minutes also reflect that that would be, at that point in time, owned and maintained by an HOA. This clause is not untypical with large subdevelopments because the build out typically is such an extended period of time that the HOA may be established and the HOA member may be the developer. But until as those lots are sold off, the HOA does have more members, but the developer would pay, if he owned 8 lots, he paid 8 shares of the maintenance. The other remaining lots would pay the difference.
All right, I'm going to stop you there for just 1 second to make something clear. When somebody applies for a subdivision application, one of the requirements of the Camden ordinance is that they demonstrate that they've obtained state approvals prior to obtaining their subdivision approval, correct?
Yes,
And in this case, it would have been the DEP approval, correct?
that is correct.
And that would have been submitted as part of the application for the subdivision approval.
Yes, and it has to be part of the record when the development is approved.
Okay, so it's clear that the language that the DEP had to limit transfer outside of a homeowners association, as you just read it, would have been before the planning board at the time they approved the subdivision in 1995.
Yes.
Okay, so that was a record before them. Can you take us through the next paragraph in your letter? This is the second full paragraph on page 2 of the notice of violation.
Yeah, and the approvals in place for the subdivision required that the common areas, including the detention pond reserved for green area parcel, would be the responsibility of a homeowners association. Conveying of this parcel to an entity other than the homeowners association violates that approval of the town of Camden's subdivision ordinance, Article 8, Section 15, Stormwater B9, which states the developer shall maintain all components of the stormwater runoff system until the system is formally accepted by the town or is placed under the jurisdiction of a legally created property owners association whose character and powers require the maintenance of the system with adequate financing to carry out this responsibility.
Steve, it's your position that this means what it says, that it has to be the homeowners association after the developer transferred the interest.
Yes, unless they come back for a modification to the approval through the planning board to make it something other than what was stated in that finding of fact.
Okay, let's go to your next paragraph about the DEP site law permitting. And just for the members listening, the board members, you've seen this in your packet and it was sent as a separate document. This is going to reference a site location of development order. It's recorded in book 1980, page 33 of the Knox County Registry of Deeds. And this specifically applies to the lots 68 to 79. Is that correct, Steve?
That was when the final approval was done, and that reflected that later DEP approval.
It applies to these lots in question.
Yeah, and I actually looked at the original one with the stormwater on it, and that had that same requirement, although it did not specifically say what homeowners association or what lots. It just said homeowners association. It reflected the same language.
All right, and so we've heard this a couple of times. I'm just going to summarize it though. What this language required, which again, this would have been before the planning board, before they approved the subdivision back in 95, correct?
Yes.
Okay, and this says that the applicant was not permitted to sell, assign, or otherwise transfer any portion of the development without prior approval of the board. And there it's talking about the Board of Environmental Protection, correct?
That, yes, because that's right out of the site law conditions.
Right. And it says specifically in the second sentence that the approval for such a transfer could be granted only if the applicant or transferee demonstrates to the board that the transferee has the technical capacity and financial ability. And in this case, the transferee is the homeowners association, correct?
Yes,
Okay. And of course, that means regardless of what a representative of the Department of Environmental Protection may or may not have said about not caring who eventually gets the property, there still is this permission that is required from the DEP before there can be a transfer of the property held by the homeowners association, correct?
correct. And I've found typically working with the DEP, they look at their own rules and they assume that the person that's calling them is going to look to the local ordinances and regulations prior to continuing down any path. Their scope of jurisdiction ends at their order. It does not extend to or override any local approvals or review requirements.
Excuse me, Bill and Steve. Will another 4 or 5 minutes suffice to wrap it up?
Sure.
Okay.
Thank you. Steve, the rest of the letter speaks for itself. There's been no, just so the record is clear, there's been no remedial action taken in this case with regard to your notice of violation. The violation still continue?
Yes, it does.
Okay. If I can, Steve, was there anything else you wanted to touch on before I turn over to Jeremy? Just a couple of follow-up questions for him.
No, I think we've covered everything that is in my realm.
Okay. Jeremy, there's been some discussion here tonight and also in some of the materials submitted by the applicant about some conversation that took place between you and the select board regarding the possible transfer of this lot. Could you comment on that from your perspective?
Sure. And I'll try to be brief and just answer the question. So I had heard that in the works, the HOA had reached out to me. Chris Mulhillville, I believe he was the vice president at one point and then became the president at another point, was understood that there was potentially an issue with this transfer, wanted to work with the town. And then Mr. Michael Carita and a butter had some concerns about this potential transfer as well. And like the subdivision ordinance says, that provides for a provision where a stormwater detention system and infrastructure, much like roads, can be accepted by the town rather than being maintained by the HOA over time. So what I did was I went to the select board in an effort to try to work with the HOA at the time to find an alternative solution, a correct solution, I would add, in my opinion, about how a transfer of this pond could happen. Because like Jesse said, and I would acknowledge Jesse's comment earlier, that there may be some inequities here, but I then acknowledge what Bill said. That's the reality of what this is. I mean, there are deeded restrictions, and these are deeded covenants that go with these lots. So that is a matter of fact. So in an effort to try to resolve this issue, I had approached the select board to gauge their interest in working with the HOA to have the town take ownership, because I do tend to agree with Jesse. I've been dealing with stormwater ponds in developments for a long time, 20 plus years. And I would correct Jesse if I can. He said it's rare that a property owner owns a detention pond. It happens all the time. There are detention ponds built and constructed that are permitted everywhere around the state, and they are owned by somebody. That said, I had tried to work with the select board to see if they had an interest, understanding that the select board themselves cannot be the ultimate deciders on this. That there would be an approval process for this, DEP site law, planning board approval. In addition, we in the town of Camden, it would also require town voter approval. So there is kind of a long process to get to that place where the town could take ownership of something. I mean, roads, when they go through subdivision approval, they have to go to the town for final acceptance. It's not the select board that can make that decision. So what I was trying to do was trying to resolve this issue, help in the bigger picture, because yes, I agree, the town has more technical ability, more equipment, more infrastructure, more staff to deal with stormwater infrastructure. That said, there's a process to get to that point. And that's what I was trying to convey to the select board at that time. I was, again, asked by Mr. Michael Creda, an abutter, who was concerned about this issue because, again, he's an abutter. He bought against a reserved green space lot. And then I was also asked by Chris Mulhillville, who I believe, again, Jesse, you may correct me if I'm wrong or ask questions later, but I believe he was the vice president of the HOA at one point and then became the president of the HOA. So Bill, did that answer your question?
Yes, that covers it. I just wanted to touch on that.
Yep.
I don't, Mr. Chairman, at the moment, we seem to have passed our allotted time. Any other comments I'll save for when we have a summary or perhaps some rebuttal questioning later.
Very good. Thank you, Bill. All right, now the chair will entertain questions from the board. Who'd like to go first?
I do have a question, but I'm going to defer until the board members have a chance to ask theirs first.
Well, while the board is thinking, I have a question for the CEO. Steve, as you've noted, and as the notice of violation notes emphatically, that there's a larger floodplain here in question. When you're talking about water runoff and potential pollution to the Magundacook River. With the current area excluded, who has control of the rest of the watershed?
The rest of the watershed is in open dedicated lands in control of, with the exception of the roads. The town has control of the roads and the ditches. There is another water channel that goes down through off from Pleasant Ridge Drive and I believe it's Jim Brown Road and runs down through and feeds directly to the pond. It's a very narrow stretch, but it's also dedicated as green space. So it actually is under the control of the rest of the owners of the development.
Okay, all right. And is the watershed area much larger than that, as you have implied in the violation?
Basically, yes, the pond is feeding most of the catchment areas with the exception of the section going up the hill on Goodwin Lane. Well, the upper end of that tends to sheet across the upper lots and go into, there's a 25-foot no-cut area down the northerly side of the development, which DEP also has in their order. That is a filtering spot to keep it from going into the next abutting property owners, which is part of another subdivision. So they typically will run stormwater into duff areas, things like that. The Goodwin Lane tends to shed down into the lower northerly corner of the lot above the detention pond. And then the area below that along Goodwin Lane sheds down through the town side of that development.
Well, let me just, one additional question. Are there any individual property owners that have a similar detention pool and green area that ultimately feeds into the Magundacook River?
No, this all goes through, pretty much everything for this development goes through this lot, with the exception of a few ditches on the very low part of the Pleasant Ridge Drive.
Okay, thank you. Members of the board, any other questions?
John,
Yes,
I have a question.
John, go ahead.
Chriso,
Oh,
Chair recognizes Chriso.
Thank you. It's a little bit of a process question that, I mean, to me, it seems relatively clear cut that the ordinance gives two options and what's been done is outside of the third option. I'm just listening, and you know, this may not be this may be a better time later. But if they want to pursue this, they then go through. This could be done through approval from planning board. Is that what they would need to have approval from planning board in order to transfer this?
I believe if you're transferring it to a party other than that, it probably would take an ordinance amendment because our ordinance is pretty specific on who can own the property. It could be transferred per se to the town without having to go back to the planning board. But to any other entity would be very tough and probably require ordinance amendments and other things.
Okay, that's kind of what I thought. Thank you.
Ron Van Ostel, chair recognizes you.
Yes, we're talking about this new lot called 78A, is that correct?
Yes.
Okay. And how many lots are in the green space that was put aside? What lot numbers were put in the green space?
They actually don't assign lot numbers to green space at planning board stage. It's just classified openly as green space. But there is the detention pond lot. There is a small thin lot that runs up across the north of that. And then there is another one that runs horizontally between the two bends and Pleasant Ridge Drive and goes over to a small catchment area, which was a naturally occurring thing back at the very first division.
Okay, so who will retain in the thought process here of those areas, the green space, maintenance of those?
Those are anybody in the development. It's basically just classified as green space and it's open for anyone in the development to enjoy, so to speak, or maintain.
Anything else, Ron?
Not right now.
Can I make a comment or just
Yeah,
help
go ahead.
and answer some of that question a little bit? There is no lot number for this lot. I mean, that would come after the subdivision approval process. So I understand that there might be a deed that references a lot number. And I think that may be the lot number that Mr. Gibbons acknowledged. If that's correct. Is that correct, Paul?
Yes, that's correct. Yes.
So from the town's perspective, I don't believe that is a lot numbered lot yet. I believe the HOA, as part of that transferring that property over to Mr. Carita, came up with that lot number. That was not a lot number that was created by the town.
I agree.
Bill Kelly here, just to follow up on that. That's the whole point of lots approved in subdivisions are done by the planning board. They're numbered, they're actual lots. Green space is not a lot, it's green space. Thank you.
Okay.
Okay, thank you.
Ron, you have a follow one or are you?
No, I'm fine. That's what I'm trying to understand.
Thank you very much. Andy, did you want to pose your question at this point?
Yeah, it's actually the flip side of the question I asked of Jesse, and I just need to understand mostly Bill's construction of the provision in question. So Attorney Kelly, I'd pose this to you if I could. Subsection 9 of Article 15, Section 15, B9 says the developer shall, and Jesse brought attention to the mandatory in the context of the developer. The developer shall maintain all components of the stormwater runoff system until the system is formally accepted by the town. We've done enough municipal law practice, Attorney Kelly, so we know town meeting approval is always a challenge. Or is placed under the jurisdiction of a legally created property owners association whose character and powers require maintenance of the system. That's interesting language. It goes on to say with adequate financing to carry out the responsibility. From an enforcement perspective, this is kind of a joint question to you and the code officer. Does the developer still exist as a corporate entity in the state of Maine? And does the developer have some obligation here? Should this enforcement action not only be against the HOA, but against the developer? Because I'm hearing equitable arguments, but part of that is a question as to whether there was ever adequate financing for the detention pond. And so if the developer, referred to in the 1992 version of the ordinance as the subdivider, no material difference. But if the subdivider has the mandatory obligation, should there be two objects of the CEO's enforcement action?
I believe Sonny Goodwin passed a number of years ago, probably about at least 5 at this point in time. Monroe and Goodwin is kind of a small paper entity at this point in time. About the only thing left is they have a small float business, which I think they've just sold off. So I'm not even sure they're in existence at all at this point in time.
That's helpful.
Well, my short answer would be, we have a deed from the developer to the homeowners association that transferred ownership as we would expect. I can't see how we would bring the developer back in at this point in time. I certainly do read the language that you read as being mandatory. I don't know how else you read it, that it has to be under the jurisdiction of a legally created property owners association. As to their financing, you know, how well do they assess their lot owners on an annual basis and collect the money and make sure it's there? I think this is more of an obligation of the homeowners association as opposed to some requirement that the town is enforcing. It seems to me it's a typical language that you expect the homeowners association to be developed so that they have a way of raising funds to maintain the infrastructure required. But I don't see who else gets notified under this notice of violation other than the homeowners association, since they are the only ones under our ordinance and the DEP order that can own this lot.
I certainly appreciate the pragmatic requirements that or circumstances that Steve has alluded to, and I certainly appreciate, Attorney Kelly, what you're saying with respect to whether the homeowners association has that obligation with respect to adequate financing. But I'm looking at the manner in which Attorney Rutter construed the language, and you could read it to say that when the developer places the stormwater runoff system under the jurisdiction of an HOA or a property owners association, he or she has to do so with adequate financing to carry out the responsibility. And if there was a failure there, is there some residual responsibility of the developer? I'm seeing a difficult circumstance where everybody's pointing at the other, saying, we don't want it, he doesn't want it. And I think we're going to hear more of that when we hear from the abutter. So I think the idea that the town normally ends up with this, when I heard CEO Wilson say that the streets have been accepted by the town, and I had heard Planner Martin, as assistant CEO, said he was trying to find a path and explore it. I think it's going to be helpful to the Board of Appeals, which you're correct, Attorney Kelly, is not a board of equity. They have to interpret the plain language of the ordinance and determine how the ordinance should be interpreted. And I'm just working with interpretive questions, and I'm not seeing any immediate answers that are practical, but that's ultimately the hardship that sometimes comes with a plain language interpretation of the ordinance. So,
well, let me add one thing to that I think is helpful perhaps to your analysis. We have to keep in mind that the deed from Monroe and Goodwin Real Estate to Pleasant Ridge was signed and recorded in 2002, 18 years ago.
Mm-hmm.
So how we would reconstruct a financial capacity question of what the developer handed off 18 years ago in 2020 is, to me, a bit of a bridge too far.
Yep, understood, Attorney Kelly. Thank you.
Okay, can we move on, gentlemen? All right, the chair now will allow 5 minutes for rebuttal from both presenters. Who would like to go first?
I'm sorry, am I afforded an opportunity to ask the appellee questions?
You are, and I apologize.
Okay, I was sitting on my hands for the last 15 minutes.
No, I really, I'm sorry, Jesse.
No, that's quite all right.
No, I blew it.
I wanted to let Andrew go first too, because he phrases his questions better than I do. And when I ask these questions, I suppose I'll defer to Bill, Steve, and Jeremy with whoever you think is the most appropriate to answer it, because frankly, I don't know. To your knowledge, is the pond lot going to change at all with respect to this conveyance?
Maybe I can answer at least my thought on that.
Oh, sure, I don't understand the question, but if you do, go right ahead.
No, go ahead, Bill. I was gonna say something similar there, but go ahead.
No, I don't have an answer.
Jesse, do you want to clarify the question?
Or to your knowledge, is the usage of the lot going to change? For example, currently the usage of the lot is for management of stormwater. That's correct, right? We can all agree on that.
Well,
that's the use of the lot.
Here's a point. I'm going to jump in here, Jeremy, if I can. Bill
Yeah,
Kelly.
go ahead.
Here's one of the curiosities of the self-help process that the homeowners association has engaged in. The deed into the corridas references restrictions regarding the green area, and yet the only entity that can enforce those restrictions by the deed's terms itself is the homeowners association, which is now dissolved. So when you say what the use may or may not be, now or in the future, there are restrictions with no one to enforce them. So I would assume they would be whatever the homeowner decides to do with it.
Well, if they started to use it as a building lot, I think we can all agree that someone would have to go in front of the planning board, because that changes the use of that lot, correct?
From my perspective, and this is, I may just try to answer this, the lot was green space, reserved land with a detention pond as part of the subdivision. So that is what the use of that lot is for. It's for the HOA. It's green space that was required and a detention pond required from the subdivision approval. So it's all of the HOA's lot, as I see it.
And if the corridas agree that it is going to be used in that exact way, green space and part of a stormwater management system that they will maintain at their expense, how does that change anything?
It doesn't necessarily change the use of the lot, but in part of Jeremy's diligence before going before the select board, he had an engineer walk the property with him. And currently that detention pond is in the need of somewhere between $7,000 and $9,000 worth of work to be brought up to standards. And the question comes as to who is the enforcement entity? And also we still have the issue that we have a lot that's not an approved lot that was sold out of a subdivision that was not approved by the planning board to be sold.
Correct. I would add that $7,000 or $9,000 is an amount that from my perspective is hearsay at this point. I've heard that thrown around is from the HOA had reached out to someone to clear some trees around the pond. That's all that I know about that cost.
And if the corridas are willing to pay that cost, whether it be themselves with contributions from neighbors, what's the problem?
I guess I have to object to the sort of speculation. We're not here about what might happen in the future with what the corridas might agree to. We're here because the transfer took place without approvals from the DEP and the planning board. So
I appreciate you bringing that up, Bill. Let me, if I may, I just have two questions related to that. And Bill, I guess this can be directed towards you first. The standard conditions, which we've all been referring to, and specifically with respect to DEP's involvement, is standard condition number 5, excuse me. It says, unless otherwise provided in this approval, the applicant shall not sell, lease, or otherwise transfer the development. Who was the applicant?
well, you have to read the whole paragraph. The second sentence expressly talks about the transferee as well. I don't
Right, when
think
talking about a transfer by the applicant. So they have to, when the applicant wants to transfer the property, they need to demonstrate that the person to whom they're transferring it has the ability to do that. Did Sonny do that? Did Sonny get approval for the transfer of this to the homeowners association, to your knowledge?
That was part of the stipulations, is it had to either be transferred to the town or a duly authorized homeowners association. He already had it
I'm
done
not
when
talking about I'm talking about the DEP standards that are contained at number 5, which requires that if he is going to convey anything, he needs to make sure any part, it says it right there, if we're talking plain language, that it gets approval. Did he get approval?
May I comment? This is Paul Gibbons. Yes, the chair recognizes Paul.
When you deal with a DEP approval, there are the general standards and there are special standards set forth in the approval itself. And that standard says the Department of Environmental Protection recognizes a responsibility to maintain the retention pond and provide that until 2002, Monroe and Goodwin has to maintain the retention pond. And after that time, it becomes the homeowner's responsibility. The Camden Planning Board minutes also state that. So I think that's where I got that from, was the Camden Planning Board minutes. But the point is that in essence, the Planning Board approved, and I think the DEP approved, the transfer of the retention pond to the homeowners association. And so to me, the bottom line issue here is the interpretations of both the DEP regulations, this order, and the Camden subdivision ordinance all protect the public when somebody has a retention bond. They want to make sure that there's someone there, there's some association capable of paying for that responsibility. If you were to interpret the language the way Jesse Rutter suggests that we do, then the two standards in the Camden zoning ordinance, it's either to the association or the developer. If you can transfer to someone else, there's no protection at all. None at all. It's a crazy interpretation. It's something that no rational person would make because you want protection.
Okay.
And that protection is plainly there.
All right. Let's wrap this up and get into rebuttal. Who would like to go first with rebuttal for 5 minutes each?
I suppose I'll go first since I've got a little bit momentum, if it's all right with
Okay, you're on.
the chairperson. I noted something in what Jeremy Martin was saying. And Jeremy, I was going to call you Jeremy, and I stopped myself. I want to be more formal with you. I mean no offense by it. You had said in response to a comment that I made, which was how many people really in private ownership have detention ponds on their land? And you in your comment said, actually, quite a few do. So this notion that a individual that somehow the public is going to be injured by a private owner who has an obligation by the DEP to maintain this stormwater management system is somehow going to be injurious to the public is just not accurate. The DEP has just as much of an ability to go against Mr. Carita if he doesn't follow the terms of what this site location plan order says, as it does against the HOA. And frankly, I think I've highlighted the point that I'm not even necessarily sure that the transfer to the HOA was done pursuant to the terms of the DEP regulations. At the end of the day, and just a point of clarification, Mr. Mulhillville, who Jeremy spoke with, he was the treasurer. He at no point was the vice president or the president. But that's just for point of clarification. The fact remains is that the owners of these lots were given no option. And they continue to have, based upon what the appellee is arguing is they are left with no option. Steve said it himself. He's like, the only way I could see that they could transfer this out is by an amendment to the ordinances. So what by not allowing this transfer to an entity who's willing to accept the responsibility and to accept the maintenance obligations, you've effectively done exactly what I've been talking about, which is render this a black hole for an HOA that they are stuck. No one has proffered any type of resolution here for these poor people. No one has, because all I'm hearing is we need we need an ordinance amendment. When is that going to happen? That's all I have to say.
Okay. Thank you, Jeremy. Jesse? I'm sorry.
That was Jesse.
Bill? Yeah.
Just, Jeremy, was there something you wanted to, you had your hand up. Did you want to add something?
No, it's okay.
Okay, so I don't have anything else other than to say, I appreciate the frustration of the homeowners. As Jesse just said, this just isn't fair, and there doesn't seem to be a mechanism for their resolution. That may or may not be, but we have mandatory provisions of both the subdivision approval and the DEP approval that we have no, and you board members have no authority to ignore. This is not a court of equity. You're not here to sort of do the right thing for everybody. We're not here to negotiate a resolution. Unfortunately, it's a fairly black and white case before you from my perspective and from the code officer's perspective. And while that might seem unfair, we all have to do our job, and the code officer has to do his job. And his job required him to issue a notice of violation. And your job is going to be to indicate that that was correctly issued. And that's all I have.
So I have a question, Mr. Chairman.
Recognizes Andy.
So I'd be interested in Attorney Kelly's thoughts on whether the Board of Appeals really should reach to try to interpret and enforce the DEP requirements. My perspective is both parties have used it for informational purposes. That's helpful. But the way I view the Board of Appeals responsibilities, they've got to interpret and apply local ordinance. We don't want to be in the position, I don't think, of applying DEP requirements. So I'm with the perspective that Section 15, 9B does impose a mandatory requirement. Mandatory as to who is going to be something that the board has to wrestle with. I'm comfortable with the discussion that's been had on that. But my question, Bill, Attorney Kelly, is do you really want the Board of Appeals trying to apply and interpret DEP requirements?
And the answer is yes, in this case, as the testimony was presented and it was uncontroverted, that in order for an application to be complete for subdivision approval, the DEP approvals had to be submitted with that application as facts alleged and facts presented to the planning board prior to the 95 approval. That would have included the DEP language. That would have been before the planning board. Those would have been facts they had before them to rely upon when they determined that the subdivision permit should be issued. So I don't think those facts can be simply ignored. That's the language in the ordinance that requires that as a pre-submission. And that's where I think the linkage is and the logic.
Andy, maybe another comment, and I don't know if I'm going out of astray here. Can I just
Yes.
throw something in? And the town threw it out in the notice of violation about the planning board approval required. Section 2 of Article 12 of the subdivision ordinance, which requires amendments and how you process amendments. I just wanted to point that out. There's a provision to revise approved subdivision plans. Section 1 is minor field changes, and Section 2 is an amendment. And just as someone else stated earlier in this meeting, there have been multiple lot line changes over time, as recently as this past year in this subdivision, with even members of the HOA when they wanted to dissolve a property line. The town alleges in our notice of violation that that amendment was required by the planning board for this process. Just clarifying that process.
Yeah, so because both parties just offered rebuttal, and this issue has been brought to us by Planner Martin, I would just ask a couple of questions of each of the parties. Article 12 does require that revisions to approved plans be approved by the planning board. There's both a substantive question as to whether the HOA could have transferred to someone other than the town. There's also the question of process, and both Title 30A, Section 4407, which applies to revisions of previously approved plans, pretty clearly says those go back to the planning board. The language that Planner Martin just referred to is a question to Attorney Rutter. says any revision to a previously approved plan shall be submitted to the town planner CEO for review. And then the only way the planner CEO has authority, other than the planning board, is if minor field changes do not alter lot lines or affect the approval criteria. Only those can be made with the approval of the planner CEO. I don't understand how this is a minor field change, and even if it were, that at least would require CEO or planner approval. I think, as has been suggested by Planner Martin, you're under Section 2 amendment, and that is if at some future date, once there's an application for an amendment, the planner CEO determines that the revision requires approval of the planning board, which would be anything that's not a field change, that doesn't affect the lot line or affect the approval criteria. I mean, we've been spending a fair bit of time talking about Section 15, which is one of the approval criteria. It affects an approval criteria. So my question to you, Attorney Rutter, is on the process issue of where you go next. Don't you agree that you have to go to the planning board before you can transfer a detention pond law?
Assuming that there is some finding that this conveyance that we have done is somehow violative of procedure, which, as I'm sure you understand, I disagree with. Steve's comments are not heartening. This is what the entire argument that the CEO and the town is making, is that to convey this out, there's two people who can have this lot. Two, the town or the HOA. So if we don't prevail here and we have to go through the process, I have no confidence that it can even be approved, because they've told me for the last hour and a half that there's only two people who can hold this. So, I think the better result here is to permit an interpretation of the ordinance which allows this property to be conveyed to an individual owner, subject to all of the provisions that the DEP requires.
Andy, can I just touch on that because your question, Andy, was about process, and I want to just focus on that. It is true that a few minutes ago, the code enforcement officer commented on the possibility of a ordinance amendment in order for this transfer to be acceptable. But none of us are the planning board. And sometimes planning boards do things that the code officer doesn't agree with because that's their job and they get that interpreted right. And they may or may not agree. Andy was probing a few minutes ago as to what that language does or does not mean in Section 15B9. Well, one of the things that will happen if you go before the planning board is you'll find out what they think and how they interpret it. But the code enforcement officer's interpretation, as it's presented in the notice of violation, is his, and it is logical. So it's not a total fool's errand, and other things can occur when you approach the planning board, including the planning board suggesting amendments, which it does from time to time. Matter of fact, it's a board of original amendment language frequently. Mm-hmm. But the code officer doesn't have the authority to do it, and that's why we're here.
Understood. So I yield back to the chair, and I do want to remind us all that one of the immediate parties is Mr. Carita, who's represented by Mr. Gibbons, and I think in the sequence of presentation, we may have either treated Mr. Carita as an interested person who might want to be given the opportunity to go first, or treat him as an abutter as though he has some higher standing than an interested person. But I defer to the chair and the board as to how you want to go
Which
next.
Which person was that again, Andy?
Mr. Carita, and represented by Mr. Gibbons, Attorney Gibbons. Yeah.
Okay.
John, I also wanted to mention that Mr. Perkins has his hand up, appearing to want to answer, at least has a question at some point, but maybe address Andy's question about Mr. Gibbons and Mr. Carita.
Well, we're coming to a point here where we can have comments from the public when rebuttal is finished.
Okay.
Will that suffice by those parties?
I'm happy to have Paul Gibbons go before me.
Okay, hold on just a second. I'd like to ask the question though of the CEO and Bill. Was it the transfer to the single abutter that triggered the violation?
Yes, that would be because they transferred a unimproved lot. That lot was not approved to be sold as part of the subdivision. That lot was intended to be retained by the members of that subdivision.
Can I assume then, or can the board assume that prior to that, had that not happened, that no violation would have occurred?
Correct. If that had remained with the homeowners association and they continued to maintain the pond, there was no violation. And also in our second letter of April 30th, we did try to lay out a path for them going forward and gave them a couple of options as far as resolution, that we would put a stay on the violation of the appeal hearing, but it involved going back to the planning board or researching the transfer of the property to the town.
So the 12 or so property owners that represented the homeowners association prior to the transfer, they were deemed by the town to supply adequate long-term protection for the holding area. Is that true?
Yes, and that's fairly typical with subdivisions throughout the state. I personally live in one that did not have an association, that had an unmaintained road. We actually had to go through the process with the state to create a legal group so that we actually did have the same protections as the homeowners association, because typically it is one, many people have the better financial capability than just one.
Okay, but just to reiterate, the 12 or so property owners constituting that association, they were deemed to be financially capable to maintain that area long-term.
Yes.
All right, thank you.
I mean, we don't have the right to inquire as to their financial stability or what they have for resources, but we have to presume if they own houses in that development, they must be aware that there are costs regarding the association as far as maintenance.
Okay, all right.
And John, could I add as alternate CEO that it was also in their deeds that this was a requirement. So we assumed that was, they were obliging with that obligation.
I understand. I would just wonder.
Okay.
Well, I won't wonder.
Okay.
I cut it off there. All right, let's move on to public testimony by interested parties via YouTube as well. And I'd like to recognize the Corriatas first. Is that suggested that?
I'm Paul
Or
Gibbons.
did I shortchange Paul?
I'm Paul Gibbons. I represent them. And I would like to have Michael Carita, if he's online, to testify.
Yes, I think I'm not muted. Is that correct?
That's right. So we are the owner of the lot in question. And the question is, how did you come to own that lot and why did you accept ownership of it?
I came to own the lot based on a majority vote of our homeowners association. Not unanimous, but majority. And I had requested of the fellow neighbors in the homeowners association, my wife and I had requested that we have the opportunity to take the lot to prevent a building lot. There was an offer that came in on, I think it would have been October 9th, sometime after the select board meeting. And that was presented for a vote. It was an expiring offer. It hadn't been mentioned, at least to either a butter previously. And it was going to be for a building and developing lot. And so I asked if we could take the green space on it and avoid any sort of development. And I said that we wanted to keep it the way it was as a green space. Questions were raised about about the process, but in short, that's how we ended up with it. And the neighbors were nice enough to allow us to have that first opportunity as opposed to the builder.
And if the building had been put there, what effect do you think it would have on the detention pond and surrounding areas?
I have not the faintest idea. We understood that, I mean, we all understand that we have one McGuntacook River, we have one chance to take care of it right. And frankly, I felt a lot better about chances to work going forward with the town, it's not a lot of fun to fight with neighbors. And it seemed like we were devolving to that kind of point, and it's not a great quality of life. So it was to try to avoid building, it was to try to protect the river, and to try to keep the peace.
Okay,
And
thank you.
if the town were to find that this transfer was improper, would you be willing to transfer this property back to the homeowners association? Can you hear me?
Yes, if the town were to find that it was improper and it was to be maintained as a green space from some party, absolutely. I mean, my concern here is, I have many concerns. I will try to limit my concern to, it has been a green space for 30 plus years. The intent was clear. We all voted on August 15th. We all voted to authorize Ed Collins, Mr. Collins, to represent us as homeowners. I am one of the 4 homeowners, of which, and I agree with a lot of what Mr. Rutter said, by the way. We all voted to authorize Mr. Collins to represent us to the planning board. And so and that's documented in the packet that I think the board has today. We all clearly understood there was a process, and then suddenly that process was gone. And rather than try to fight from the outside, and as I said, it's not fun arguing with neighbors. I don't want that. We requested the opportunity to take it on and preserve it.
All right,
Thank you.
I'm going to move on to the next interested party.
That's Mr. Perkins.
John, Jesse Rutter has his hand up.
Yeah, I just want a point of clarification, and it's and not an insignificant point, but a brief one. The offer that came into the HOA on October 9th was not for a building. It was to maintain it as green space, and the letter of intent was specific as to that. It was not going to be converted into a building lot. It was going to be
Can I respond to that briefly? We saw a survey, and again, this is in the packet the board has, that specifies potential.
Excuse me, folks, I'm going to allow another minute for this, so please wrap it up.
Okay. We saw a survey that identified potential home sites. That's the way it was phrased. I asked the question, could this become a building site? And the answer was yes. So while we weren't describing a house, that's my background. Thank you.
Right, but my point is that was never pursued, and the offer that came in on October 9th, or that was discussed on October 9th, 2019, pursuant to a letter of intent, was going to keep the lot exactly as it is now, as green space and as part of the storm management system, not a building. That's my only point.
Okay, thank you, Jesse. Thank you, Vincent.
So just a brief question, if I could, to Attorney Gibbons, Board Chair Cool.
Permission.
Paul, you wrote a memo to the board dated July 8th, just the other day. And I assume that both you and the Caritas are aware of what's in that memo. Is that a fair assumption?
Yes.
Okay. And so do you stand by that memo, which is pretty explicit in terms of the thoughts you have with respect to both Title 30A and the local subdivision ordinance and the DEP approval requirements? Do you stand by that memo tonight?
Yes. My position was that the first paragraph is why my client did this, but the question is whether the approvals are required. I stand by those, that both the DEP requirements and the local subdivision ordinance require require that this be put in the name of the developer or a homeowners association, or they had to get DEP approval, none of which happened.
And just from an evidentiary perspective, I take it that each and all of the parties before the Board of Appeals have, in essence, offered into the record tonight the materials that have been previously submitted, and that would include your memo, Attorney Gibbons.
Yes. Yeah.
Andrew?
I would ask that of Attorney Kelly or Planner Martin or CEO
or Jesse
Wilson.
Yes.
Can I just also, I mean, Jesse had brought up or inquired with our office this morning about the subdivision ordinance that was in play back at this time, back in 1995. I just want to make sure that everyone knows that we provided that to Jesse. And this should be part of the record too, because there was some question about the 95 zoning or subdivision ordinance and the current subdivision ordinance. I will say that both of the language in both of those ordinances speaks to exactly the same language.
I acknowledge receipt of it, and I believe Andrew pointed it out before that the only distinction I believe is the distinction between developer and subdivider. I think that's the only difference.
Yeah.
But thank you.
Okay.
We'll treat all those materials then as part of the record. I wanted Attorney Kelly and Attorney Rudder to have the chance to say anything that you submitted you don't want to go into the record, because we'll treat it as part of the record.
No, I'm comfortable with the record.
Okay. And same for you, Attorney Kelly?
Yes, it's all part of the CEO file, even though some of it might be considered negotiation. It's also part of the normal process after a notice of violation is issued. So as far as I'm concerned, it's all submitted and admissible.
Very good.
Okay, are we ready to move on?
Defer back.
All right, I believe we have Mr. Perkins queued up
Yes.
for 2 minutes.
Excuse me?
2 minutes, please.
I may need more than that. I'd ask that because of all the people that are participating in this meeting, we are the only people who actually have a realistic chance of suffering personal harm from this situation. So it's very important to us, and I will not be repetitive, and I will try to keep it brief, but not only does this water pass across our property right now, but when there's a storm, it roars across our property. And previously, when there was a failure up there, it came across in an uncontrolled manner. And that leads to actually, that's why I want to have a little flexibility here. But I will say as a footnote that I am an attorney. I'm still an attorney. I retired a few years ago, but 40 years. And as a footnote, I have to say I did represent Mr. Beveridge, and I probably should have put that on the record, but that was 30 something years ago, and I hope you won't hold it against me. At any rate, I agree with Paul Gibbons' memo, what Bill Kelly has said in the general principles that there is a process for having subdivisions modified, and it involves the planning board. It doesn't involve the code officer, doesn't involve the selectmen or the zoning board of appeals or anyone else. It's a simple process that you have to go to the planning board. And, I mentioned the harm and the potential harm because that's where, in my opinion, financial capacity is really important. Because if someone collects water and then shoots it at you, that creates liability. And the liability is on the homeowners association, and the people who are members of that homeowners association have an obligation to pony up to cover the costs and expenses of the homeowners association. So the financial capacity is very important to me. And in spite of what Jesse said, I think there's a very big difference between having one lot stand behind obligations and having 12 lots stand behind obligations. There is a big difference. And that would be, if there was going to be a change in that, that would be for the planning board. And then I'd have a chance to go talk to them, and I probably wouldn't be held to 2 minutes.
Okay, thank you.
But at any rate, I want to take you to the one interpretation that Jesse offered, that somehow it can go to the developer and then to the homeowners association. And that's the end of it. That's all that the planning board can say about it. Because after that, the homeowners association can turn it over to anyone they want. Because it doesn't say they can't. So let me ask you, if you have a homeowners association, first of all, planning board is made up of public officials who take an oath and they have to be disinterested. The homeowners association is 12 people who have already said that their prime motivation here was to get rid of the obligation. Let's vote it out of here. We don't want to have any responsibility for this. Now, if Jesse's interpretation is correct, that homeowners associations can do that, would there be anything wrong with them saying, and I'm not going to ask you to fill in the names, but think of the least financially responsible person each of you know. Would it be perfectly okay for the homeowners association Because it doesn't have to be someone who owns other land. Can they just turn this over to the least responsible person they know? They don't have any public charge. The interpretation of the ordinance that would allow that to happen would render the ordinance and the statute utterly meaningless. You'd have people examining the financial capacity of the developer. You'd have people looking at the homeowners association. Then after that, forget it. They can just give it to anyone they want. That's absurd.
Mr. Perkins?
Thank you. The end.
Thank you. You made your point. Okay, all right. Are there any other people of interest coming forward?
John, I'm not seeing anyone raise their hand of the Contentos or Mr. Yuri. I'm going to unmute Mr. Flick because I can't see him. Mr. Flick, do you have any questions as an interested party?
Or comments?
No, I think we've figured out the direction of things this evening, and I have nothing to offer at this time. Thank you.
All right, thank you.
Okay. All right, now we move to questions from the board.
John, it's Ron.
Yes, Ron.
Yes, please excuse my internet's is quite slow right now because I'm at the end of a DSL. So I got a lot of people getting on this type of evening, and so it slows down and I miss a lot. The question I have is this lot, as was described by some of the paperwork as lot 78A, it's clear that that lot, we use it, does not exist. Is that
Hey,
correct?
Ron, excuse me, I'm sorry, maybe I've just misunderstood. Who are you asking the question of?
The question of the let me ask the question of the attorney for the I'm sorry,
Bill Kelly?
Kelly would be my guess.
Mr. Jesse.
Oh,
You're asking of
Is
Jesse?
Jesse on?
Yeah, no, I'm here. There was the interpretation, the deed doesn't say lot 78A. It was a way of when this discussion was taking place at various homeowners association meetings and discussions with the town and the DEP to kind of designate it as something. I don't mean any of that to suggest that it's been given a lot number, and the deed to the Caritas doesn't reference it by that number. It's just a designation. It could have been called anything, frankly. But I think it assists in the discussion because it lets everyone know where it is between lots 78 and 79.
But as far as, all right, so 78 and 79 do exist?
Yes.
Yes. Okay. Is that part of the green space?
No.
No. Okay. So all the green space is in this undetermined lot number 78A. Is that correct? All
correct. What I've called the pond lot, but yes, it's a space between lots 78 and 79.
So it's the entire green space.
No, there's more green space up the hill from this lot and also around the corner.
Okay.
Well,
let's
just clarify maybe, Steve, this subdivision, this phase of the subdivision, the only green space in this phase of the subdivision is this green or detention pond lot that Mr. Rutter refers to.
Okay, fine.
Yes.
Thank you. Okay, thank you. That's all I want to clarify.
Okay. Chizo, did you have a question? Is he still with us?
Yeah. I have a question probably for Mr. Kelly. In the case of other areas where I am familiar, catastrophic failures of these types eventually, if it happens, involves a lot of people, not the least of which is the town, which owns the infrastructure that participates in this detention pond. What do you see as a critical line there as far as the town's liability is concerned? Certainly individual homeowners association, contractor, all have the potential for that, but because the town contributes with their ditches and impervious surfaces and that type of thing, is there a potential for the town to be held liable in some remote situation?
You mean for the relating to the pond lot, if it should fail? Yeah, at present, the answer is no. That kind of discussion and consideration is always made when the town takes legal control or legal authority over the pond, which it has not done yet. So at present, the answer is no.
Thank you.
Okay. Thanks, Steve. Anyone else with a question? Okay, at this point in time then, I'm going to close the public hearing and open the floor for board deliberations.
Okay, John, this is Ron.
Yeah, Ron.
As I look at this, and I just have to take the information as provided against the guidelines that we've been given by the town. I guess the question is, I see no avenue out other than to affirm that the violation stands based upon the guidance and an interpretation of the information I have provided to me by the submittees, that the violation should stand.
Yeah, I tend to agree with you.
Can I just suggest to the chair and to the board members something? Yes. I think because this is a de novo review, you should start with a question of what you think the ordinance requires in your own original determination, as opposed to trying to feed this back through the CEO's determination. If this was a purely appellate review, you'd be taking the question of whether the CEO was right or wrong. Now what you need to do is make your own original determination as to how you would apply Article 15 of the stormwater standards. So it may not make a difference in terms of where you come out, but that's your duty under a de novo review. So if you could start again, Ron, and just indicate whether you think Article 15 applies and how you would apply it to the facts.
All right, can you point me to the Article 15 again?
Yep. So I'm just going to read it to you and make sure that you've got it handy to you. But it's the subdivision ordinance, and it's Article 15. And I'm not sure. Do board members have the subdivision ordinance before them, or is it just easier if I read that, John?
I'm picking up my copy.
The orders for the.
So the subdivision ordinance, and this has been the central subject of the discussion tonight. So the text of it is before you. It basically says the following: the developer shall maintain all components of the stormwater runoff system until the system is formally accepted by the town or is placed under the jurisdiction of a legally created property owners association whose character and powers require maintenance of the system with adequate financing to carry out this responsibility. That's the provision. And the question is either A, how do you interpret that provision? Do you think it allows transfer outside of the four corners of that provision? Or alternately, how do you apply it to these facts where there was a transfer from the HOA to a single property owner?
Well, the HOA does not exist anymore.
But that's not the question. And actually, administrative dissolutions can be undone just as quickly as they occur. So
but they haven't been,
that's not the question.
I know. All right.
Well, let me jump in here with a comment.
Please.
A single family dwelling does not qualify as a homeowner association by what you've just read, I believe, or did I hear wrong?
Yep. So as chair, you're making a suggestion for another board member to make in the form of a motion that you think that the transfer to an individual property owner does not constitute an HOA. And we can build from there. I think that's a starting point, John.
Yeah, that's what I'm saying, and I don't see how you can escape that, and I'm just commenting now on the impact of the various homeowners, and especially Mr. Perkins. That's all very unfortunate misunderstanding here, but it's inescapable how we deal with the notice of violation as we're being called upon to do. We really can't consider all these other bad things that happened. We have to deal straight up with the violation. I don't see any other way around that. That's for starter. Now, maybe there's something beyond that we can do, and that's going to be even more complicated. But I would clearly support the notice of violation in the proper language. That's where I'm coming from.
So if I can take two pieces of what you're saying that, in your opinion, a transfer to an individual property owner would not fit the language of Article 15 B9 in the subdivision ordinance. It appears on page 42 of the subdivision ordinance. And then the second piece you're saying is that the transfer from the HOA violates the ordinance.
That's right. Is Jeannie still with us?
Yep.
Yes.
Hi, Jeannie.
Hi, you woke me up, sorry.
Well, I'm wondering, you've helped us before put our thoughts into words.
I don't think it's at all appropriate this evening. I think this is your decision, sorry.
Yeah.
So do we need a motion to that effect?
Yes.
So I would make the motion that as we reinterpret the statute, or what John just said, as rephrased by Andy, I don't know if you need me to restate it, but I would make that motion.
So the nature of your motion, member Rowe, is that you interpret, as you interpret the ordinance, specifically Article 15 B9, it does not permit a transfer. It does not permit an individual property owner to hold the
lot in
stormwater runoff system. And so a property on which the stormwater runoff system is located has to be held either by the developer or the homeowners association or the town. And
Correct.
a single individual, a single property owner is not any one of those three categories.
Correct.
And so therefore the transfer from the HOA to the single property owner violates the ordinance.
Correct, exactly.
Okay.
Yep.
Like you read my mind.
Yeah, that's fine.
Are those words coming together, Jeannie?
Yes, yeah.
Okay, can we have a read back then, possibly?
Yeah, we're working on it.
You want to do that, Andy? I mean, I can give it a stab.
I'm almost there. I'm almost there. So
Point of clarification, just for the record, Andy.
yeah,
You're actually dealing with Article 8 approval standards, Section 15. 8. We don't have an Article 15 in our ordinance.
Correct.
yep, yep, fair enough. So what is the article number?
It's actually Article 8, Section 15,
There
then
you go.
sub 9, I believe it is.
Subsection 9, subsection B9, right?
B9, yes.
Yeah. So as the board interprets the ordinance, specifically Article 8, Section 9, Section 15, subsection B9, that provision only allows a property containing a stormwater runoff system to be held by a developer, the town, or a property owners association, ... You can assume that the ellipsis contains the language of Article 8, Section 15, subsection B9. And then the second, I think it's proper to vote first on that motion before we get to the second motion, because that's an easy two-part motion. So Member Rowe, do you want to cue that up as your motion?
Yeah, so I would make that motion.
I defer to the chair for it to ask for a second on the vote.
I will second the vote. And we'll call.
So Member Rowe made the motion. Who is the member that seconded?
John Cool.
Okay, John. It's in order for a review and a vote.
All
There
right.
can be discussion before there's a vote.
Anyone have some comments?
John, this is Ron. Can you repeat the motion because I lost connection?
Sure. As the Board of Appeals interprets the ordinance, specifically Article 8, Section 15, subsection B9, that provision only allows a property containing a stormwater runoff system to be held by a developer, the town, or a property owners association.
Got it, Ron?
Yep.
Okay, it's been seconded. Still open for discussion? Hearing no discussion. John French, still not with us. Ron Van Ostal, how do you vote?
Yes.
Steve Beveridge,
Yes.
Chris Rowe,
Yes.
John Cool, I vote yes. Hope I didn't miss anybody. Having heard that and made that motion and voted on it, who else has some comments here about further direction? Any other
Well, do we need a second?
conclusions that might lead to some help? And I'm really grasping here.
But do we need a
Yeah, go
second?
ahead, Member Rowe. Yep, you do need a second one.
So I would make a motion that the violation stands.
No, there's a
I'll let
second
you
predicate that's necessary. You've determined that only 3 entities can hold a lot containing a stormwater runoff system, and that is the town, the developer, or homeowners association. I think your next predicate is an individual property owner does not fall within any of those 3 categories. Does that sound acceptable to somebody who might want to make that as a motion?
Yep. So I would make that motion that an individual homeowner does not qualify.
I will second that. Any discussion around that point? Hearing no discussion. Ron, how do you vote? Ron? Ron Van
Yes.
Ostal. Hello, Ron. I see him.
Yes, yes.
You vote yes. Steve Beveridge.
Yeah, I know. Yes.
Yes. Okay, I got you. I'm going for Steve Beveridge.
Slow it down.
Steve, how do you vote?
Yes.
Chris?
Yes.
And John votes yes.
And so the last step, I think, Chairman Cool and members of the board, is that the transfer from the property owners association to the individual property owner violated the ordinance.
I will make that motion.
Second.
Second.
Discussion? Steve, how do you vote?
vote yes.
Chris,
Yes.
Ron,
Yes.
me, yes. What else do we need, Andy?
So I don't think you need anything further for this determination. I would just offer that I think the resolution of this problem now goes beyond the Board of Appeals. And I think there's any number of ways that could move forward because you do have three choices. I think the board has decided that which they need to decide for this evening.
Well, along that line of thought, and a discussion I think is worthwhile here. But of course, we need your cues. Can we make recommendations, so to speak, or findings based on an advice to the town, for instance, as to how to proceed and with what haste? And then, and as I say that, I think of Perkins and the fact that time is of the essence. Mother Nature provided a pretty good demonstration of what he's going through there. And I think the board should find some way to get somebody's attention. And if we have the power to do it, I think we should do it.
Bill Kelly here, if I could weigh in for just a second. I think the board needs to be very careful to go beyond the issue before it and the findings, because issues could come back before you at a later date. They could also be remanded from Superior Court, possibly. There could be other notices of violation, and you need to not get into opinion and policy issues. Thank you.
Okay, I was looking for our judgment on that. I got it.
I appreciate Chairman Cool the important aspiration for these parties, because they clearly feel stuck. And I just would offer that I think those efforts that have gone before this proceeding to try to find ways to find a result are always helpful. But I don't think the board has more within its jurisdiction this evening than the appeal of the notice of violation. And you've resolved that. And I don't think anybody feels great about it, but you discharged your duty. And for tonight, that's it.
Well, then the same rationale applies to the abutting, I'll use the term 78A would-be property owner. You understand what I mean?
Yes.
Okay, all right.
Before you adjourn, could we address the fact that John French was not present at all in any way during this proceeding, and should we count him absent or present?
I think he helped to form the initial board, but because he couldn't effectively participate, I was waiting for the opportunity that you've now just suggested, Gene, to see if John wanted to cast votes if he was participating. But I think he could not effectively participate, so he can be noted as present. But then I think after you speak with John, you need to find out what factually happened, and we can reflect that in the decision of the board. I just don't think he participated in any of the votes or the deliberations. So
is that based on, you're saying that based on what I just said, or no?
Say again, John Cool.
Are you basing your comment on what my casual observations there about Mr. Perkins? Or is that completely independent issue about Paul?
No, she was asking about John French.
Oh, I'm sorry.
No worries.
And how to record
I'm sorry.
How to record the vote as 4-0?
Yeah, we were 4-0 on everything. We called on John to vote a number of times, but he was in transit or nonverbal.
Yeah, you would say 4-0 to 1 if the member had to abstain, but he just wasn't present for the vote. So I think you're correct, Gene. 4-0.
Well, and not only that, he never did have a response to the first question, which was biased. conflict of bias.
Yeah, he couldn't get a connection good enough to even communicate.
No, he was not here.
Yeah. Well, I think we can sort that out. That's not material to
Okay.
these proceedings.
All right, I
Yeah.
didn't know if it had to be on the record. Okay.
So, Mr. Chairman, unless there are any other questions that need to be resolved, I think a motion to adjourn is in order.
I think so too. I'd like to make a motion to
I
adjourn.
move we adjourn.
And before I do that, I really want to thank the entire board and everybody involved here. And I also want to thank Andy and Jeannie for dealing with a slow student. Me. Thank you very much. But do I hear a motion to adjourn?
So moved.
Second? Everyone in favor? Steve,
Yes,
Aye.
yes.
thank you to the board. Thank you, thank you.
Thank you all.
Thank you, members of the board. You did fine.
Thank you all.
Have a good evening, all. Take care.
Good night.
Good night.
Good night, Jeannie. Done. Hey, Helen?